May I have
Any
my lord's,
mentioning?
may I have my lord's kind leave to mention for enlistment, my lord, there was an order for making an amendment. My lord. There was a dot which was, my lord, extra put in the petition, for which, my lord, we are now, my lord, we have filed a petition for amendment. My lord, I'm only praying for enlistment of that petition, my lord.
This is original side matter.
It's an original side matter. My
No,
lord,
the
this is the
second half,
last
second half you have to mention. The court officers are not there.
come back. Deeply obliged.
My lord, may I be permitted to mention one matter, group 1, for inclusion in the list, my lord?
Year?
Hearing, my lord.
What is the year of?
2019, my lord.
19 আছে তো?
Lords.
নোটিশ দিয়েছে?
Item number 1.
Lokhi Gupta is appearing. A short passover, my lord.
Who is appearing?
Steel Authority of India. Mr. Lokhi Gupta is appearing on behalf of Steel Authority of India.
Yes, Passover.
I'm grateful.
Passover.
Item number 2.
Two টা গুরু না এখন Passover করে।
Kindly keeps it at 2 p.m. my lord.
2 p.m. I will take up original side matter.
No, kindly, my lord, I have fixed, my lord, do a distribution bench, my lord.
Then I'm making it not today.
Well,
কোথায় সে কোথায় গেল?
Short date may kindly be. No, not today.
Item number 2.
Yes. Sure. He's the
My lord, Mr. Bandavata is on the way. My lord, let the petitioner start the case.
yes. Agus in
Kindly.
wait, just a minute, just. Yes.
Kindly looks into the order dated 2nd September 2018. I'm placing the order. The present writ petition is launched against the order dated 30th August 2018, passed by the Subdivisional Magistrate Jalpaiguri, directing to vacate and deliver possession of RS plot numbers 121, 122 and 123 in sheet number 18 of Mouja, Binaguri, District Jalpaiguri to Commandant 12th Battalion within 1st September 2018. It was further indicated therein that failure to deliver the possession within the specified time may invite the enforcement of the said order through the NGP police station. The petitioner states that a copy of an order dated 28th August 2018, passed by the appellate authority, was never served upon the petitioner. It is thus stated that keeping the petitioner in doubt and depriving him to take further steps against the aforesaid order, the present impugned order is passed in haste to render the further remedy provided under the West Bengal Land Eviction of Unauthorized Occupants Act 1962 illusory and non-est. Since the demolition is to be carried immediately after 1st September 2018, the writ petition was placed before the Honorable the Chief Justice to move on urgent basis. The Honorable Chief Justice granted leave to move the writ petition today before this court. Since urgency has been found by the Honorable Chief Justice and also upon perusal of the averments made in the instant writ petition, this court dispensed with compliance of the provisions under Rule 26 of the rules in relation to Article 226 of the Code. The case appears to have a checkered history, as the petitioner moved the court on an earlier occasion challenging the various actions and the orders passed by the authorities under said act. A show cause notice was issued by the collector under section 3 of the said act, as in his opinion the petitioner is in unauthorized occupation of the land in question and invited the reply to the same. The petitioner participated in the proceedings which ultimately culminated into an order for delivery of possession passed under section 4 of the act. Section 7(1) of the act provides a remedy by way of an appeal before the commissioner of the division when the order is passed by the collector, and therefore the petitioner approached the district magistrate who entertained the appeal by accepting it. The said appellate authority initially disposed of the appeal on 1st June 2018 by dismissing the same, which was challenged by the petitioner in WP number 7195 of 2018. The said writ petition was entertained on 4th June 2018, and this court restrained the commandant 12th Battalion, Jalpaiguri, and also the police authority from giving effect to the order dated 1st June 2008. The said writ petition ultimately came up before this court on 14th June and was disposed of by setting aside the order dated 1st June 2018, as the said order was bereft of any finding. The matter was remanded to the appellate authority to consider afresh after giving opportunity of hearing to the petitioner and to be disposed of within 4 weeks from the date of communication of the order. My attention is drawn to the various documents annexed to the writ petition, wherefrom it appears that the appellate authority directed the field inquiry to be conducted before proceeding to decide the appeal finally, and according to the petitioner, the same was done. The appeal was fixed on 17th July and was concluded, but no order was passed by the appellate authority on the said date. The said appeal is disposed of on 28th August 2018, and if the statements made in paragraph 35 of the writ petition on oath is believed to be correct, then the said order of the appellate authority has not been communicated to the petitioner. If the authority has passed an order and did not communicate the same to the affected person, it cannot have any legal efficacy. The reference can be made to the judgment of the Supreme Court in such and such. I'm skipping the judgments. Now straightway comes to furthermore. The authority, while keeping the said order with them, has hastily proceeded to pass an order for taking delivery of possession without giving a reasonable opportunity to the petitioner to take steps as permissible in law. Section 7(2) of the Act provides a further remedy to any person aggrieved by an order of the appellate authority to file an application before the state government within 30 days from the date of such order on the ground.
Yes.
File an application before the state government within 30 days from the date of such order on the ground of gross error of facts or law, or both. Such statutory right cannot be frustrated by giving the order of the appellate authority in file, by keeping the order of the appellate authority in file, and hastily proceeding to take delivery of possession. There is another reason which the court feels and invites interference with the impugned order. My attention is drawn to the declaration made under section 6 of the Act, 1 of 1894. There is no reflection of RS plot number 122 therein, and the petitioner is all along contending before the authorities that the plot was never a subject matter of acquisition and was never recorded in the name of the state. If the plot of land is not included in the notification under section 4 of the declaration under section 6, the authority must record a positive finding as to why such properties are public property and the occupation of the petitioner is unauthorized. This court therefore finds strong prima facie case. There shall be stay of the impugned order dated 30th August. So far it relates to RS plot number 122 in sheet number 18 of Mauja Binaguri for a period of 7 days from date or until further orders. The aforesaid order is passed solely relying upon the statements made in the writ petition on oath and treating the same to be correct and true and correct. Petitioner is directed to serve copy. The matter is made returnable on 6th under the heading listed motion. Let us plain copy. Now, my lord, after this order was made, my lord, I am not taking your lordships to the development which took place in frustration and in violation of the order, because, my lord, it appears that, my lord, we have filed a supplementary affidavit, placing it on record on the 13th of September 2018. Kindly see 13th September 2018.
without having any intention to interrupt my learned friend, my lord. My lord, the affidavit in the main matter is not completed. He will place this order 18 September. Your lordship will find in the second last page, towards the concluding portion, that we were only at liberty to file an opposition to the supplementary affidavit, which was filed by them alleging certain contumacious act by us in violation of that order. So in the main matter, my learned friend will not be able to show from any order. I have scanned myself. There was no direction to file any affidavit. This is only something I'll pointing out to your lordship, my lord, before a lot of time of your lordship is taken away in the introduction of the matter. Because ultimately I'll make this point that I am still not at liberty to file an opposition to the main matter. My opposition is only restricted to
After
supplementary.
September 18, you have not been given any opportunity to file affidavit.
No, my lord, kindly see September 18th order, 18 September's order. Kindly takes towards the third last paragraph. The court feels that the state should respond to the allegations made in the supplementary affidavit. So we have restricted our opposition to the supplementary affidavit. And thereafter, there is no order as far as filing any opposition is concerned.
Acha. When did you file the supplementary?
My lord, 13 September order kindly sees.
What to be kept with the record? Okay.
13 September 2008.
Yes. It is affirmed on 7th September 2018.
My lord, my lord,
Okay,
my lord.
this is written affidavit on behalf of the petition, not a supplementary, but
That is a supplementary.
okay.
My lord,
So you have filed your opposition to supplement.
Supplementary affidavit. And if your lordship, I am not taking your lordship through the supplementary affidavit. The paragraphs in the supplementary affidavit where we have dealt with the pleadings clearly state that it is only restricted to the supplementary affidavit.
Okay. Is it so, Mr. Bhattacharya, that
Lord, there is no quarrel with that. I
Okay.
cannot dispute whatever my learned friend is saying.
okay?
I mean, Lord, what can be done is, my lord, for the ends of justice, my lord, if my learned friend, my lord, comes with an affidavit in opposition so that we also respond to it, my lord, the pleadings be completed in the main petition, and my lord, we come back to your lordship, my lord, on any day
Okay.
convenient,
So-
my lord, but very short time be granted.
2 weeks time will do. 2 weeks you will complete that.
Yes,
1
a
week
fortnight.
he will get a 1 week time to make reply. After 3 weeks this will be listed. Mr. Shirshonno Bandyopadhyay, learned advocate appearing for the state, indicates that though the state respondents have filed their opposition to the supplementary affidavit, but no such direction was issued for filing affidavit in opposition to the main writ petition. He seeks to file affidavit in opposition. Let such affidavit in opposition be filed within a period of 2 weeks. A reply there to be filed within a week thereafter. List this matter after 3 weeks. After 3 weeks.
My lord, my lord, no, my lord, bhai, our 4 weeks, 3 weeks, question, my lord, later date be fixed. My lord, I'll just give you a lordship. If it comments to your lordship, my lord. Today we are on the my lord 7, 14,
18.
21, 28. my lord. Let it be fixed on 28.
But it's a কাজ করুন 31st পরে একটা ডেট বলুন ফার্স্ট উইক অফ ফেব্রুয়ারি ফার্স্ট উইকে দিন হ্যাঁ 5th ফেব্রুয়ারি
No. ও আচ্ছা আচ্ছা কবে সরস্বতী পুজো কবে ও
Grateful.
Item number 3.
Lord, this is my application. Now, my lord, before I proceed with the matter,
Lordship, I am appearing on behalf of the
Kindly
respondent.
have a look at this order, my lord. What I will be praying before your lordship, that this is a proceeding arising out of, my lord, the Metro Railway Construction of Work Act, 1978. Now challenging the order of the quantum of compensation that has been assessed by the competent authority followed by the appellate authority, I move this writ application. Now, my lord, subsequently I find that Act provides that Section 17, that Land Acquisition Act has no manner of application so far the Metro Railway Act is concerned.
Okay.
So challenging the virus, I have filed a writ application. Now the writ application is of 2023, my lord, pending before the my lord Justice Aniruddha Rai. And this matter was also tagged with that matter, and that was also appearing.
It has to
But-
be released, no?
My lord, so that both the matter can be tagged either before your lordship, or we will be praying that both the matter may be heard together.
Can you release the matters for the time being?
Lordship,
My lord, so that my lord,
Mr. Amit Kumar Pan, learned advocate for the petitioner, submits that a writ petition being WPA 22023 of 2023 has been filed
আমাদেরকে just একটা নোটিশ
sure, sure.
নোটিশ আমাকে একবার পিং বা কল করে জানালে হয়ে যাবে।
ধরুন There go out of release
এটা কাগজ দাও।
appropriate bench.
ডিটেইলসটা নিচে তোমরা তো নোটিস করবে।
তাহলে কি করে রিলিজ হবে?
মেট্রো রেলের
হ্যাঁ শুভঙ্কর স্যারে যুগে Yes.
The matter of 2004 has been released by that bench.
Yes, because my lord, for want of determination. Otherwise, this was tagged with that matter. The subsequently during the course of hearing, what is found that this is a matter of 2004, so the lordship has got no determination. Now we are supposed to take up this matter of assignment, so matter appearing before your lordship. Now fact remains that both the matters are issue are same, but in that matter I have challenged the virus. So it has got great effect. If the writ petition is allowed, then that will affect the my lord, the determination of compensation. That's why we want, my lord, that both the matters may be heard together.
বললাম,
Lordship pleases to
Um,
tag the matter 2023 matter.
I cannot tag it. I can
that is
release the
reason
matter for
this is
assignment.
the problem we are facing.
Mr. Amit Pandani advocate for the petition submit that the petition BWPA 22023 of
Has been
2023
filed
has been
challenging the virus of which act? In 2023, virus of which act has been challenged?
Madam,
Metro
Madam,
Railways
I-
Construction.
Metro railway construction.
Virus of Metro Railways Construction of Works Act 1978 has been challenged. The present writ petition needs to be heard along with this aforesaid writ petition. He seeks that the matter be released so that he can seek for assignment of both the matters before a particular bench. In view of such submissions, the matter is released from the list of this court.
Item number 4.
Naam Sadiq.
Item number 4, I'm for the petitioner, my lord.
It appears Asmanur Coil. You are for the petitioner?
I'm for the petitioners, my lord. Petitioner number 1, my lord, is a company
registered under the Companies Act, being represented by the petitioner number 2, who is its managing director, my lord. Now, my lord, the petitioner company is the owner of certain plots of land which are mentioned at page 5, paragraph 2 of the writ petition, my lord. Kindly comes to page 5, paragraph 2.
দেখো তো এটাকে একটু নামানো যায় গো, একটু স্লাইড দেখো, আমি এটা তুলে দেবো যতটা নামানো যায়। হ্যাঁ, ঠিক আছে।
Page 5, paragraph 2, my lord, the plots of land have been mentioned, my lord. That is situated at Moza Raisinda, jail number 211, Khatian number 169/2, PS Kharagpur Town, District Paschim Mednipur, plot number 86, measuring about 20 decimals, and plot number 86/332, measuring an area of 5 decimals, my lord. Now, my lord, the petitioner company got this plot of land by virtue of a sale deed, which is annexed at page 29 of the writ petition, my lord. Now, my lord, the subject matter of challenge in the writ petition is the land acquisition proceedings, my lord, which have been initiated in respect of these plots of land on the ground, my lord, that the land acquisition proceedings, they are flawed on the ground of various procedural irregularities as well as other illegalities. Now, my lord, the first point of challenge is that two separate land and acquisition proceedings have been initiated in respect of the self-same plots of land. The first, my lord, is LA case number 14 of 2006-2007. Kindly comes to, my lord, page 36 of my writ application.
What is the land measuring? What is the measurement of the land?
My
Measuring?
lord, the measurement is, my lord, 20 decimals. That I have stated at page 5, paragraph 2.
Measuring
Measurements
20
are-
decimals within which plot?
Plot number 86, measuring 20 decimals, and plot number 86/332, measuring an area of 5 by 5/6 decimals.
86/2.
86/332.
332.
Yes, 86/332.
Measuring
5/6 decimals.
5/6.
Yes, that is what is there in the paragraph, what I can find.
I 1/6.
I apologize, my lord. Actually, in my petition, it's not legible.
Your sale deed has a schedule to the 6 decimals.
The schedule in the sale deed, my lord, that is mentioned at
Measuring this. What is the date of the sale deed?
the date of the sale deed, my lord, that is on 11th of July, 1995. That I have annexed, my lord. It starts from page 29.
1995.
Yes, my lord. 11th of July, 1995. It
Oh.
starts from page 29, annexure P1.
Both these plots of land has been acquired.
Acquired by the petitioner company, my lord, by virtue of the sale deed.
Both the lands have been acquired by the state.
By the state, my lord, and my primary challenge
We'll come to that one by one. Both the land has been
been acquired by the state.
acquired. Yes.
My lord, now my primary challenge to these land acquisition proceedings, my lord, is that they are flawed on the ground of several procedural irregularities as well as other illegalities. Now, my lord, the first point of challenge is that two separate land acquisition proceedings have been initiated in respect of the self-same plots of land. The first land acquisition proceeding, my lord, that is LAP case number 14 of 2006-2007, which was started by way of a section 4 notification dated 27th of November 2006. My lordship will find that at page 36 of my writ application, my lord. This is the first land acquisition proceeding in respect of these plots of land. Page 36.
LAP
Pardon, my lord?
case number?
LAP case number 14 of 2006 and 2007.
Page 37.
Page 37, yes. The notification starts from page 36, but the case number is mentioned in page 37. And my plots are also mentioned, my lord. At page 38, my lordship will see the land schedule, plot number 86. And at page 39, from the fifth column from the bottom, my lord, plot 86 by 332. The plots of land are also mentioned.
86.
Page 38, my lord.
Hmm.
The plot numbers. The first plot which is mentioned is plot number 86. And at page 39, from the bottom, the fifth column, plot number 86 by 332.
Yes.
Thereafter, my lord, a second land acquisition proceeding, my lord, in respect of the self-same plots of land were initiated in the year 2007. That is, my lord, LA case number 11 of 2007 to 2008. And that was started directly from the from publication of a declaration under section 6 without any prior section 4 notification. That my lordship will
That is
find
11 LA case number 11 of 2000.
11 of 2007 to 2008.
This is at page number.
The declaration under section 4, section 6, that my lordship will find at page 40 of my writ application. And the plots, they have been mentioned, my lord, at page 42, plot number 86. And then again at page 43, the third column from the top, plot number 86 by 332.
Yes.
So, my lord, this is the first point of challenge. Two land acquisition proceedings initiated in respect of the self-same plots of land. The first one was initiated by way of a section 4 notification. Subsequently, no section 6, nothing. Thereafter, my lord, in the year 2007, without dropping the first proceeding, a second proceeding is initiated right directly from the stage of section 6, my lord. This is the first point of challenge. Now, my lord, kindly comes to the second point of challenge, which is, my lord, though the land, it was sought to be acquired for a public purpose, employment generation and economic development of the area, my lord, which would be apparent from page 37. If my lordship would kindly comes to page 37 of the writ petition. May I read, my lord? Whereas it appears to the governor that the land, as mentioned in the schedule below, is likely to be needed to be taken by the government undertaking development areas at the public expense for a public purpose, viz. Employment generation and socio-economic development of the area by setting up telecom and allied industrial units in the respective plot, my lord. So this was the purpose for which the plots of land were acquired, my lord, in terms of the notification. Subsequently, my lord, though it was sought to be acquired for a public purpose, the lands were made over to a private entity, which is Ganpati Flour Mill, which is the respondent number 8 in the writ petition, my lord. Kindly comes, there's a sale deed, lease deed, which I have annexed. 11th of September 2011, the lease deed, it starts from page 58. This is a lease deed which has been executed by the West Bengal Industrial Development Corporation in favor of the private respondent number 8, Ganpati Flour and Foods Private Limited. Kindly comes to, my lord, page 62 of the lease deed, clause 6.1. Kindly comes to, my lord, page 62 of my writ application, clause 6.1 of the lease deed. May I read, my lord? Whereas the collector, Paschim Mednipur, after acquiring the lands measuring such and such acres comprised within Mouza Ruisundas, Rupnarayanpur, etc., herein after referred to as project land under the Land Acquisition Act 1894, for the public purpose of developing Vidyasagar Industrial Park for setting up manufacturing industries. Over there, my lord, the purpose was different. Over here, the purpose mentioned is different, and subsequently it is being made over to a private entity. Now, my lord, these were the two grounds on which my writ application was admitted by a coordinate bench of this court, and also an order of injunction was passed that let no activity be conducted in the plots in question till disposal of the writ application. That order, my lord, is also there on record, my lord. It was passed on.
Yes.
It was passed on, my lord. I'll just place the order.
29 September.
No, my lord. The order dated 3rd June 2014. It's a very elaborate order where the issues were dealt with by the Honorable Justice Shonjit Banerjee, as his lordship then was. The order dated 3rd of June 2014, my lord.
Yes.
May I read the order, my lord? The grievance of the petitioners is that though a notification was published pertaining to acquisition of a part of the petitioner's land bearing plot numbers 86 and 86 by 332 at Mouza Ruisunda, jail number 211, PS Kharagpur, which has been challenged by the petitioners by way of a writ petition in this court, by subsequent acquisition proceedings for an entirely different purpose, a part of the land comprised in DAG numbers 86 and 86 by 332 is said to have been acquired and a deed of lease executed by the West Bengal Industrial Development Corporation in favor of one Ganpati Flour and Food Private Limited. It is the case of the petitioners that without the previous acquisition proceedings being actively dropped, subsequent acquisition proceedings could not have been initiated. It is also the petitioner's case that no notification under Section 4 of the Act of 1894 has been published in connection with the subsequent notification of the relevant land for the purpose of setting up the Vidyasagar Industrial Park. It is unfortunate that though the state was represented on May 13, 2014, it has not been represented on subsequent occasions. The requiring body and the allottee of the land are represented, but they cannot deal with the petitioner's contention that the entire acquisition was flawed since no notification had been published and the petitioners had not been aware of the acquisition proceedings. Let a copy of this order be reached to the office of the learned government pleader for the state to be represented when the matter appears next week. Hence, the subsisting order of injunction will continue till expressly vacated. So, my lord, these issues, they were elaborately dealt with and an order of injunction was granted in my favor. Now, my lord, on this aspect as to whether the land can be handed over to a private entity, my lord, I'm placing reliance on one judgment. This is, my lord, by the Honorable Supreme Court in Royal Orchid Hotels Limited, 2011, 10 SCC 608.
Which paragraph? Paragraph?
Yes, my lord, I'm just placing it. I'm just unable to locate another copy of the judgment, my lord. It was here. Yes. Yes, my lord. The relevant paragraph, my lord, that would be at, my lord, page 631, paragraph 37. May I place the paragraph, my lord? Page 631, paragraph 37. The pleadings and documents filed by the parties in these cases clearly show that the corporation had made a false projection to the state government that the land was needed for execution of tourism-related projects. In the meeting of officers held on 13th of January 1987, after almost 4 years of the issue of declaration under Section 6, the managing director of the corporation candidly admitted that the corporation did not have the requisite finances to pay for the acquisition of land, and that Dayananda Pai, who had already entered into agreements with some of the landowners for the purchase of land, was prepared to provide funds subject to certain conditions, including transfer of 12 acres, 34 guntas land to him for housing building projects. After 8 months, the corporation passed a resolution for transfer of over 12 acres of land to Dayananda Pai. The corporation also transferred 2 parcels of land in favor of Bangalore International Center and MS Universal Resorts Limited. These transactions reveal the true design of the officers of the corporation, who first succeeded in persuading the state government to acquire a huge chunk of land for a public purpose and then transfer the major portion of the acquired land to a private individual and corporate entities by citing poor financial health of the corporation as the cause for doing so. The courts have repeatedly held that in exercise of its power of eminent domain, the state can compulsorily acquire land of the private persons, but this proportion cannot be overstretched to legitimize a patently illegal and fraudulent exercise undertaken for depriving the landowners of their constitutional right to property with a view to favor private persons. It needs no emphasis that if land is to be acquired for a company, the state government and the company is bound to comply with the mandate of the provisions contained in Part 7 of the Act. Therefore, the corporation did not have the jurisdiction to transfer the land acquired for a public purpose to the companies and thereby allow them to bypass the provisions of Part 7. The diversification of the purpose for which the land was acquired under Section 4, subsection 1, read with Section 6, clearly amounted to fraud on the power of eminent domain. This is precisely what the High Court has held in the judgment under appeal, and we do not find any valid ground to interfere with the same. More so because in Ananya versus State of Karnataka, the High Court has quashed the notifications issued under Section 4.1 and Section 6 in their entirety, and that judgment has become final. So, my lord, here also the factual matrix is similar, my lord. It was acquired, it was sought to be acquired for a public purpose. Subsequently, it was transferred to a private entity, my lord. Over here, my lord, I place the notification, my lord. The notification clearly says it's being acquired for a public purpose for the development of telecom and allied industrial units. That is the 2006 notification. Subsequently, in 2012, my lord, the West Bengal Industrial Development Corporation, which is supposedly the requisitioning body, they executed a lease deed in favor of the private respondent number 8, Ganpati Flour Mills. And over there, my lord, the purpose for acquiring the lands is completely something different. It is mentioned Vidyasagar Industrial Park, which finds no mention, my lord, in the previous notification, my lord. And the third ground of challenge, my lord, is that these lands, they come within the area of the Midnapur Kharagpur Development Authority, my lord. Now, for a development of the area, my lord, of these plots of land, my lord, the state has delegated the power to the Midnapur Kharagpur Development Authority, my lord, since these areas come as planning area under the West Bengal Town Country Planning Development Act of 1979. I have annexed the notification in my writ application, my lord. The notification, that is, my lord, at page my lord, kindly comes to, my lord, page 89. Annexure P6.
Yes.
May I place the, my lord, notice?
Yes.
Whereas the Midnapur Kharagpur Development Authority herein, referred to as the said development authority, has been constituted under notification such and such, dated 10th of October 2003, of the Urban Development Department Town Country Planning Branch under the provisions of West Bengal Town and Country Planning and Development Act of 1979 in respect of the planning area already declared as per schedule under notification such and such dated 5th of November 1993 of the said department. I'm just skipping the next two paragraphs. The fourth paragraph, my lord. Whereas pending preparation of land use and development control plan of the planning area, the Midnapur Kharagpur Development Authority has prepared and adopted the land use and development control of a certain portion of the planning area having regard to the land use and development control plan of the entire planning area, which in its opinion is considered necessary for securing proper planning of the area and which is to be included in the land use and development control plan for the planning area as contemplated in the said section, the details of which are available in the office of the Midnapur Kharagpur Development Authority Zilla Parishad complex for public inspection. Now, my lord, the fifth paragraph. Now, therefore, in exercise of the power conferred upon the undersigned under section 45 read with section 56 of the said act, this public notice is hereby issued and published proclaiming that after coming into force of this act into the aforesaid planning area and subject to the provision relating to the development charge and other provisions of the act, no development institution or change of use of any land shall be undertaken or carried out in the aforesaid planning area as stated in the schedule annexed herewith, clause A, without obtaining certificate from Midnapur Kharagpur Development Authority certifying that the development charge as leviable under this act has been paid or that no development charge is leviable. And my lord, there's also a provision in the West Bengal Town Country Planning Act in my lord section 10. I'm just placing the section. This section. I can answer. Section 10. My lord, I just have one copy. May I just place it and hand over a copy to my lordship? This is section 10 of the West Bengal Town and Country Planning Development Act of 1979.
Photocopy করুন।
Section 10, my lord.
Give that copy.
Does
কতটা আছে দেখুন। আমাদের কি আছে টাউন প্ল্যানিং এর? এভাবে অসুবিধা হবে। এই বইটা আনাতে হবে যে। হবে না। পুরোটা জেরক্স করা সম্ভব নয়। অনেকগুলো পাতা আছে। বইটা আনাতে হবে। জাস্ট আমি দেখি আমি এতে নেটে পাই কিনা।
ছিল এখানে। My lord, may I just place the section, my lord?
I can, it will be, I cannot follow that, no?
No, no, my lord. I'll just place it and I'll hand
I
over.
have to see that what you are reading, I have to follow.
I apologize. Lordship, we have found a copy.
What is the act? West Bengal?
My lord can take this copy. I found a copy from the
Okay.
internet. I apologize, my lord. Actually, I just had one
Okay,
copy, my
sorry.
lord. I apologize. My lord, section 10.
Ah.
This is the power to withdraw a planning area from the operation of the act, my lord. Section 10.
Yes.
May I read, my lord? The state government may by notification withdraw from the application of this act any planning area or part thereof. So, my lord, there's nothing on record at least to indicate that since these lands, they come within the purview of the Midnapur Kharagpur Development Authority, prior permission for any change or development in respect of these lands needs to be taken from the authority. Section 10 of the Town Country Planning Development Act that speaks of withdrawing the application of this act from any.
Where from I will get that this plot of land are within the
Yes.
Midnapur?
I'll just place that, my lord, as well. I'll just place that. My lord, kindly comes to page 91 of my writ application. This is the jurisdiction and area of the Midnapur Kharagpur Development Authority. In the second column, my lordship will find that the Midnapur municipality that comes within the jurisdiction of this authority. Page 91, my lord. The second column. And this fact has also not been controverted by any of the respondents in their affidavit in opposition as well, my lord. Page 91, Midnapur municipality that comes within the purview of these.
This Moja is under municipality here?
Yes. It comes, it's my lordship will see, my lord, in the schedule of the plot of land. The police station is Kharagpur town that comes within the Midnapur municipality.
Okay. Yes.
So, my lord, these are the three grounds on which I've challenged the land acquisition proceeding. Firstly, my lord, two land acquisition proceedings initiated in respect of the self-same plot of land. The first one from the stage of section 4 in the year 2006. The second one, my lord, in the year 2007, directly from the stage of section 6 without any prior section 4 notification and without dropping the earlier land acquisition proceedings. Secondly, my lord, though the land was sought to be acquired for a public purpose, subsequently in 2012, the land is being handed over to a private entity, my lord, which is the private respondent number 8. And thirdly, my lord, no prior permission from the Midnapur Kharagpur Development Authority, my lord, was taken, and without anything on record to substantiate, my lord, that any section 10 notification was published where the lands were withdrawn from the application of the concerned authority, my lord. These are my points. And on the second aspect, I've placed reliance on that judgment, my lord, whether it can be handed over to a private entity once it has been acquired for a public purpose.
Yes. State.
Other means Dr. Vimal Raj filed an application. That matter is hard. Thereafter, repeal will be hard. Silks and damages. Happy business. These are being a matter is code number 3. That point has already we have taken.
When did you file your affidavit in opposition? Supplementary. Yes.
19th year of May 2023.
Which is the date? Date of affirmation?
19th day of May 2023.
May 26. কবে হচ্ছে দেখুন তো কবে যাচ্ছে কবে নেক্সট উইকে হলে আর দেখে নিন 14th এটা কন্টিনিউইং ম্যাটার শুনবো কিন্তু 14th 19th জুলাই কবে হচ্ছে বলো 19th অনেক দেরি হয়ে গেল 17th দাঁড়াও আমি দেখি নেক্সট উইকে তাহলে 15 16th দেখুন না ওয়েডনেসডে থার্সডে 16th
marriage ceremony in my house. I should be out of station or so I will be coming back on 9 to 19.
তাহলে ফেব্রুয়ারিতে চলে যাবে 19th আমি তো আবার থাকবো না
7th, 8th, 9th. 7th, 8th, 9th.
7th is today
February. Why do you February?
no I'm thinking of in the month of January
I'm sorry. That's right.
taken in 13th আচ্ছা 13th next month 13th
My lord, may be permitted to come back with written notes of argument along with the compilation of judgments on the next date.
not required taken note of but Mr. Spence so learned advocate for the petitioner who concludes his argument Mr. Prashanto Behera Mehta, learned advocate for state respondent, seeks accommodation to place his points of arguments. Place this matter on 13th January.
Item number 5.
ক্যানটা কি আছে? ক্যান একটা আছে দেখাচ্ছে 5-এ।
Affidavit of repeal. Affidavit
What is can 1?
Can 1.
And Mr. Ali is for? Well, you are appearing for? Can 1. Early hearing. That's it. Affidavit in reply.
This is a case relating to a mining lease.
देखिए मिस्टर तुलसीदास रॉय एक स्टेट के लिए कोई प्रॉब्लम the other parties they have been added, the parties who have been they have been added, and the copy has been served upon any affidavit of people considered to serve copy. This has been served upon the added respondents. They give the affidavit. Affidavit of service.
Yes.
Who appeared for the state in this matter?
One of the affidavits have been exchanged and all the affidavits in opposition and the reply is there. Following this read petition, my lord. My lord, 2 notices have been impugned, my lord, which are in annexes P4 and P5. My lord, P4 your lordship will kindly find at page 96. And P5 at page 97. Yes. My lord, got it.
94.
Page 96 is P4. Yes. My lord, this is a demand notice. I am pressing the demand notice, my lord. Demand notice as for assessment report of penalty on shortfall. Penalty on shortfall for the period from 1/9/2009 to 31st August 2010. It appears from the report of the DLLRO, District Land and Land Reforms Officer. That amount of rupees 2,10,000 is yet to be deposited from your end for penalty on shortfall for the period from 1/9/2009 to 2000. This is one. And my lord, the next notice is P5 at page 97. In pursuance of the additional directorial land records, white letter so and so, you are requested to make necessary arrangement to initiate proceeding under the provision of PDR Act, Public Demands Recovery Act, against Mrs. Stody Minerals for non-payment of dues arising out of penalty for shortfall. assessed by the MOC Purulia zone for the period 1/9/2009 in connection with the long-term mining lease for granite over so and so. The details are enclosed for your kind reference. These are the two notices. Now the next notice, my lord, that comes from the office, that is P6. P6 is coming to certificate officer. That is also a part of the entire writ petition in which I have been challenging. So, my lord, your lordship finds that it is an alleged penalty for shortfall. What is a shortfall? My lord, your lordship got it that there is a mining lease. Admittedly, there is a mining lease. I am the lessee. It is with regard to the mining of, my lord, granite located at Purulia. Now, for that, an agreement has been made. Lordship will kindly find the agreement, my lord, the lease agreement, that your lordship will kindly find, my lord, at page 27. Page 27. It starts from page 27 and annexure P1. Coming.
Yes.
My lord, slowly I am proceeding, my lord, for my convenience, my lord. Page 28, your lordship goes. This is for a mining lease for granite. Page 28, first line. For a mining lease for granite. Your lordship got it? And page 29, your lordship goes. Towards the fifth line, it is a lease for a term of 20 years, thence next exceeding yielding. 20 years.
29.
Fifth line.
29.
Page 29, your
20
lordship got
years,
it?
yes. 20 years, yes.
So a mining lease for mining granite for a period of 20 years.
Yes.
Now, my lord, there is a very specific clause. This is a specific clause I will take your lordships to, which will be very important, my lord, for our purpose. At page 55 of the agreement, your lordship goes. This is the lease agreement. Page 55. Page 55. My lord goes to clause B. Page 55, clause B. My lord, the clause B starts, the lessee shall extract and dispatch. These are very important, my lord, for my purpose, subject to your lordship's confirmation. The lessee shall, it is an obligation on my part. The lessee shall extract and dispatch minimum 200 cubic meter of granite from the leasehold area per annum. Per annum. Failing which, penalty to the tune of double the amount of royalty. It also comes across another term, royalty. Which penalty to the tune of double the amount of royalty that should have accrued on the shortfall quantity shall be realized from the lessee at the end of the year. That is the shortfall. That means under the agreement, my opponents, my lord, they want to say that, well, you are under obligation to extract and dispatch. Now, I will lay emphasis upon these two particular. It is with a conjunction and. Extract and dispatch. It cannot be severed. That's only my contention before your lordship.
Okay.
It cannot be severed. Therefore, what is the shortfall? What is the notice about which I have impugned before your lordship? It is the shortfall of that 200 cubic meter. For that, penalties have been imposed. Penalty have been imposed. Now, how has the penalty been imposed? My lord, in the impugned notice, P4, my lord, P4 is the notice issued by the Additional Director of Land Records and Surveys. P4, that there is a shortfall. What is your source of information, Mr. Additional Director? I am asking myself that. What is your source of information? You have disclosed it. It appears from the report of DL and LRO. DL and LRO's report dated 19/2/2014. 19/2/2014. That is the report. That is the source of the impugned notice. For which period? 1/9/2009 to 31st August 2010. After 4 years, it was a report from which it appears that there is a shortfall. And that shortfall is liable to be penalized in a particular amount. Now, with regard to the report of the DLLRO, what is my stand? I have explained it. That you must have calculated that every month what is the discharge, because it is every month I have to. Under the terms of the agreement, my lord.
Per annum.
200 cubic meters per month.
Per annum.
Yes, 55.
Yearly.
Yes. 200 cubic meters per annum. That means per annum, you must have calculated. Place it before the court. That you have calculated. Because, my lord,
This report is annexed to the affidavit.
In the affidavit, there is no reply. There is no annexion.
What is the contention of the state with regard to this report?
Lord, I don't know. They have done it. But my question is, my lord, that when you are charging me that I have to make some payment, you being the state, you have to explain every bit of your action. After that, you can realize 1 rupee from me. Otherwise, it will be an undue enrichment. You cannot do that.
Yes.
So, my lord, my specific grievance is, there was no particulars. And in my application, my lord, your lordship will kindly come. I have said it. Paragraph 7 of my writ petition. Paragraph 7 of my writ petition is page 9. Page 9. Paragraph 7. Paragraph 7 is here. Paragraph 7 is
Yes.
Yes. Suddenly, the petitioner was served with a demand notice issued by the respondent number 2, being so and so, by which a claim of rupees 2,10,000 was made as alleged penalty for shortfall for the period so and so. And the said claim was made on the basis of a report of the respondent number 4. In the said notice, no amount of alleged shortfall and no rate of penalty was disclosed. and the said claim was made without giving the petitioner any opportunity of hearing of self-defense. That is my demands before you. Yes, you are entitled to charge me because I am bound by my own agreement that I have to extract and
P4 is the notice. P4 is the notice. You say that no notice was given.
you must know. You must hear the statement of, say, your extraction and dispatch. There is a shortfall, a violation of page 55, and therefore you have to pay. Now the penalty, that penalty also has to have a rate. The royalty also has to have a rate.
Okay. So proceedings was initiated under the
So initiation of that proceeding, initiation of the notice, it was totally, my lord, in my respectful submission subject to your lordship's confirmation. It is totally an arbitrary one. It's a desk work. Without giving me any opportunity, I am to pay. Yes, I don't say I don't have any liability. I have, provided if I can give you good explanation for that, then certainly you have to consider it. But a question might come from your lordship. Did you give any explanation? Was there really any shortfall? And I am bound to answer that question. I shall answer that question. And I shall answer it, my lord, from the very agreement I have made. If I can give you reason that there is a shortfall for this purpose or that purpose, and that purpose you have to consider also, that I shall come to. Then the last point I shall take your lordships to, about your ability, legislative competence, to charge for any penalty at all under the law. I shall take your lordship to that point also. You have to answer that question. Whether you have the legislative competence. You don't have. In my respectful submission, I'll come to that, my lord. Now, my lord, therefore, there is a shortfall. And this shortfall, my lord, your lordship didn't find, my lord, do not find any calculation. What is the quantum of shortfall? In which period, in which year this was the shortfall? Because it is for the period of 4 years. For a period of 4 years, that is 1st September 2009 to 31st August 2010, 4 years.
yes.
Yes. So my definite charge against you, that really you issued the notice, you didn't give any particulars, neither of the shortfall, nor about the amount of the penalty, which you are entitled to do that, nor about in a particular year what was the shortfall. It is for 4 years, nothing of the sort. This is my allegation. In allegation, my lord, in paragraph 7, you have come up with an opposition to reply to that. What is your answer? Affidavit in opposition. What is your answer in paragraph? Koto? Page 1. Page 1. Joseph, page 1. Well, it is at page 10. Page 10 of the affidavit in opposition. Car affidavit for all. Page কত 10 page 10 para 9 page 10 paragraph 9 এটা দিয়েছে এই নোটিশটা এটি 3/5/2011 দিয়েছে আমাদের দিয়েছে 3/5/2011 Lordship kindly finds I further say that the amount of 2,10,000 was claimed as penalty on shortfall on the basis of assessment of mining officer so and so for the period from 1/9/2009 to 31st August 2010. In the said letter, the amount of shortfall and rate of royalty are clearly stated. Where are these things? That when the mining officer, it is the mining officer in charge, he has submitted a report giving particulars. Am I not entitled to get it and to controvert it? Okay, this is not correct. That is my charge. That I was given no opportunity. Very well. You might not supply it to me. The report of the mining officer.
Now, what is your answer to this particular letter?
Yes, my lord. In
What
the
is your
said letter, the amount of shortfall and there are clearly stated. My lord, this letter, it is an internal correspondence between them.
Yes.
Very well. If it is an internal correspondence and you are the landlord, therefore, you have every right, whether you will give it to me, whether I have a right to controvert or not, your lordship will consider. But that letter of the mining officer, you might not have disclosed in your affidavit in opposition. Is not the court even entitled to know it? And I am throwing a challenge. I am throwing a challenge to them that you don't have it at all. Had it been there, it is a writ court, a court of affidavit. Here no person is called upon doc to be established. It's a court of affidavit, and you have given this. Your statement is sufficient. When my challenge is there, and what is the reply?
Yes, reply.
I repeat and reiterate my statement, paragraph 7. My reply is paragraph 19 at page 6 of the reply. At paragraph 19, my lord, I have given my reply that I repeat and reiterate my statement in paragraph 7 of my writ petition.
So it is your case that the notice at annexure P4 though been given, but the calculation portion of the mining officer has not been given to you.
It not been.
That is arbitrary, you say. So you are not given any opportunity to deal with those calculations. Okay.
But my lord, while I'm challenging about the shortfall, I mean the quantity of the shortfall, my lord, I know that I am going to face a very serious question from your lordship. Mr. Ali, do you admit that there was no shortfall at all? My lord, I admit there was shortfall. There were shortfalls. I admit it. But if there were shortfall, there must be some reason. Well, if that reason commends to your lordship, in that case, the quantity or any other thing, that remains a secondary part to be considered as to whether you have given this opportunity of natural justice. That's a secondary part. But I had my lord's shortfall. Well, let me be came before the court. I must be honest to myself. Lordship kindly goes to in my writ petition. Paragraph 4 onwards. My lord,
Just a minute. Para 4.
my lord, your lordship kindly takes up my writ petition.
Para 4.
My lord, your lordship kindly gives me liberty to I place it. Paragraph 4 onwards, 2-3 paragraphs I will place. After obtaining the possession of the said mining lease, the officials of the petitioner found that there are residents of tribal people and people of backward classes which are very close to and adjacent to the leasehold area of the petitioner. And as such, the petitioner had to restrict the blasting operation drastically. My lord, mines require a blasting, my lord. Yeah, it is a common knowledge, my lord. Mining requires blasting. Restrict the blasting operation drastically, for which extraction of mineral was reduced to a great extent. And then furthermore,
Yes.
when over the officials, petitioner company wanted to carry on mining operation, the local people raised serious objection and threatened the petitioner's official with dire consequences. As a result of which, the petitioner had no alternative but to suspend mining operation for a long time, every year. The mining activities of the petitioner was also obstructed due to non-availability of proper access road to the leasehold area, since there was only a kacha narrow road leading to petitioner leasehold area from the main road, which was not fit for plying heavy vehicles, and all these obstructions continued till 2012 to 2013. This is one. Did I keep it within my sleeves? A question I'm asking to myself. All these problems. Did I keep it secret within my sleeves? No. Not to go to page paragraph 5. During the previous year 2011, the petitioner informed the mining officer in charge regarding the factory causing obstruction, regarding the factors causing obstruction to petitioner's mining operation, which was duly received at the said office on 5/9/2011. An affidavit of declaration was also affirmed on respondent's request by one Rajkumar Todi, director of so and so, on 28/5, stating on oath the aforesaid factors causing obstruction to petitioner's mining, which was also submitted before the respondents. I didn't keep it within myself because I have gone there to do my business. And I know very well that you are my landlord. I have certain obligations. Those obligations I have to pay. Well, a question naturally comes. Well, have you been fulfilling your obligations? Yes, I was. What are the obligations, my lord? Well, the obligations under this agreement and also under the law. I have to pay royalty. Admittedly, I was paying it. Second, I have to pay dead rent. Admittedly, I was paying dead rent. I am to pay, my lord, the the site areas for that rent is to be paid. I've been paying it. I've stated it in my petition. All these financial obligations I am paying. The dispute is with regard to the quantum of extraction and transfer during a particular period. These are the difficulties. Should you or should you not consider, my lord, is a question of myself, my lord, I put it. They did not. Because it is on their request I have given an affidavit. But what is their answer? In affidavit in opposition,
No, first
in
take me
reply
to
to
the
my
affidavit. P2 and P3, the affidavit that was filed before the respondent authorities stating of the factors that is causing hindrance to the extraction.
Yes.
Where is that P? You have annexed to the writ petition?
The affidavit আমরা ওদের কাছে দিচ্ছি আছে সেটা আছে my lord, I am just searching it. My lord, it is there. Now the question is, why it is there? Yeah, I'll take your lordship to page 83 of the agreement. Well, it is everybody's knowledge that whenever a lease agreement is made, a force majeure clause is there. It's a common knowledge. And in a pro forma agreement of all types of lease under the Transfer of Property Act or mortgage or everything, a force majeure clause is there. Here also there is one. A force majeure clause, which is there at page 83 of the petition, page 83. Yes. At page 83, paragraph 4. There are some force majeure clause.
Yes.
Or I know that I am going to face your lordship's question. What are your force measure? These are the force measure you have said. Has it been catalogued as a force measure in your in your agreement? Or I will say yes. How? Or in page 83. Just towards the end, the paragraph your lordship says. Force measure means page 83, my lordship got. Force measure, the last two lines. Force measure means act of God. War. Is it war? No. Insurrection. To a little extent, it is insurrection because the people were giving me no. Even my officers were threatened to death. Riot. Civil commotion. Is it not a force measure? Not only that, storm, tidal wave, flood, lightning, explosion, fire, and other happenings which the lessee could not reasonably prevent or control. I could not. Because you are the owner of the entire area. If any law and order problem arises over there, well, I cannot control it. I'm your tenant. It is your obligations to control. Under my respectful submission before your lordship is that by way of an affidavit I have informed you, even in writing I have informed you that these things are happening. My lord, even if in your affidavit in opposition, did you inform the court that After having received all this complaint, we made an inquiry and it was found false. No, there is no negation of it. There is absolutely no negation of it. Now, if there is no negation, it is an affirmative. You have admitted the situation. Yes. My lord, I have submitted before your lordships with regard to my financial obligation. I was very honestly, I was fulfilling it. Where is that? My lord, in paragraph 6, page 9 of my writ petition. I have stated that. Page 9, paragraph 6 of my writ petition. That the petitioner was served with demand notices with claims of so and so, with claims of cess, surface rent, dead rent, which the petitioners did not dispute. I did not dispute. And payments were also made according to such claims. So this is paragraph 7.
What is there?
Paragraph 6, my lord, in paragraph 6. So I have been making payment of all those.
Yes.
And my benevolent landlords, my lord, did not have any material even to, my lord, iterate about paragraph 6 in their affidavit opposition. Nothing. That means they have nothing to say.
Six has not been denied also.
Yes.
Paragraph 8.
So, my lord, so far as other obligations regarding financial obligations, my lord, they have nothing to say. The only, my lord, objection with regard to that non-payment for
Page 10 of the affidavit in opposition, paragraph 8, deals with paragraph 6 of the writ petition.
page 10.
Paragraph 8.
Yes, my lord. Yes.
They have denied.
I deny and dispute the statement made therein. What are matters? I further submit that dead rent, service rent, which says thereof, have not been paid by the petitioner company to the state government till date, in spite of serving demand notices upon the petitioner, which are duly acknowledged by them. We have. There is no notice. There is no demand. That is not the demand. the demand is with regard to this. My lord, this is what it is. Now, so demand, my lord, with regard to the shortfall. I have given my explanation. This explanation in my respectful submission covers the force majeure clause, which you may accept, you may not accept. But whether it has been accepted or it has been rejected is not known to me. It remains over there. So far as my case with regard to the factual aspect, this is the factual aspect. Now, my lord, I will take your lordships to the question involved in law. Yes. My position. Yes. Now, my lord, so far as my lord, this is with regard to the mines and minerals. My lord, as we all know, my lord, this is a I'm grateful, my lord. Yes. My lord, with regard to this payment of the shortfall, this quantity, my lord, there is, it is, আমি আগে এটা বলে নিই আগে এটাকে বলে নিই। এটা বলে নিই। My lord, mines and minerals, my lord, this has been, my lord, listed in list 1 of the Constitution 7th schedule. In 7th schedule, list 1, it has been listed as item 54. Seventh schedule, list 1, item 54. A regulation, got in, my lord. A regulation of mines and mineral development To the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest.
Yes.
So it is under the legislation is to be made by the central legislature because it is incorporated in the first schedule, in the seventh schedule, item 7th schedule, list 1.
Item number.
Yes, central. Well, it has been placed in the concurrent list as well, but that is altogether a different issue. Concurrent list কোথায়? আছে. But my case is here. আছে. List 3.
List 2.
Yes.
List 2.
List 2.
7th schedule, list 2, item number 23.
Yes. List 2, item number 23. Yes. Regulation of mines and minerals subject to the provisions of list 1.
Yes.
Subject to the provision of list 1.
So it is not
With
that this.
respect to regulation and development under the control of the owner. Therefore, it is subject to the one. It is very reasonably understood, my lord. Because the constitution makers, my lord, they are well apprised of the situation that the eminent domain with regard to the subsoil or the eminent domain of this mines and minerals is with the central government. But fortunately or unfortunately, these mines are located in different states.
Yes.
So it is located in different states. Therefore, the administration of the mines, my lord, has not been left over to the central government in list 1. In list 2, it has been incorporated because with a delegated legislation, the state governments can do it. That is what it is. My lord, why I am saying so? Even with the mines and
Mines and minerals আছে আমাদের?
my lord, I'm
Oh, this.
it is marked, my lord. Huh? No. Mines and mineral development. Mines are 1957. I begin my your lordship will get the West Bengal minor mineral rules. The West Bengal minor mineral rules. In the very beginning, my lord, West Bengal minor mineral rules in the very beginning. Yes. West Bengal minor mineral rules, it was in exercise of the power.
Yes.
The rule, how the rule has been framed. In exercise of the power, you also got it, my lord. Conferred by subsection 1 of section 15 of the Mines and Minerals Development and Regulation Act, as subsequently amended, so and so. Therefore, it is by virtue of the Parent Act. The Parent Act is this one. The Parent Act is Mines and Minerals Development and Regulation Act of 1957. That is the Parent Act. Under this Act, my lord, in my received submission, my lord, subject to your lordship's confirmation, that this West Bengal mines and minor mineral rule concession rules, minor mineral rules, that has been framed. Perhaps your lordship got it, my lord, that was 2002 rules is there.
Yes.
2002. But these rules has been amended, not amended. It has been completely repealed. Completely repealed. However, I'll come to that. Subject to your lordship, my lord, giving me. I shall come to that. So this is a delegated legislation under the Parent Act, which was promulgated by the central legislature. Therefore, the control of the legal responsibility with regards to mines and minerals, it is the central government. Even the administrative body only, under the delegated legislation. So long that delegated legislation remains on board, you have the power. The moment you don't have that power, you can't do anything. Because you have been directed, you have been given a delegated power. I take out my power. And you are powerless.
Yes.
So, my lord, you have been working, you have been exercising your power under the 2002 rules, which admittedly, according to my submission, subject to your lordship's confirmation, is a delegated piece of legislation under the Central Act. The total domain of control, management, even the regulation, is totally dependent upon the central legislature. It is their power. Now, if by virtue of that power, certain power has been delegated to you, and it has been taken out, you don't have any power. Provided by the repeal, if any power has been given to you to do something in any manner whatsoever. This also, as we all know, my lord, is a trite law. Now, this 2002 law, West Bengal minor mineral rules. My lord, West Bengal minor mineral rules, when you are working under that particular power, my lord, there a condition was given. That condition is according to that 200 cubic meters per year. I have. If there was not, there is a shortfall. And if there was a shortfall, for that shortfall, my lord, in 2002 rules, in 2000, your lordship kindly takes rule 21. 2000, my lord, it is flagged. 2002 rules, rule 21. Lordship got it, my lord? Yes. My lord, it is E. These are the conditions. All these conditions have been laid down in the agreement. This is the con. The lessee shall extract and dispatch. My lord, repeatedly, my lord, even without irritating your lordship, I shall repeat this word. Look, the legislature uses the words very consciously. Extract and dispatch. Therefore, if you have to consider the shortfall, you have to consider not only extract and dispatch these are together. You have done this, put it before the court. My challenge is you have not. Because whether you have done it or not, I do not know. You did not give me any opportunity. Now, I have given you certain things, my lord. Lordship kindly goes to E. I was referring to E, clause E of Rule 21. The lessee shall extract and dispatch the minimum quantity of mineral from the leasehold area annually.
Yes.
So and so as prescribed in the lease deed. In case there is any shortfall of the extraction and dispatch, again extraction and dispatch of the said minimum quantity without any satisfactory reason, penalty to the tune of twice so and so should have accrued so and so. Therefore, without any satisfactory reason, that means there may be satisfactory reason. And, my lord, the explanation is there. The reasons will be regarded as satisfactory if they are as mentioned in the explanation to Subrule 4 of Rule 16. In such cases, the lessee has no charge to submit documentary evidences supported by an affidavit to the concerned authority, which I have done. But what is your reply? What is your answer? Did you consider that?
Yes.
Apart from the clause of post measure,
No, that is what has been stated in the affidavit.
so now, my lord, you were working, you have, my lord judge, issued these notices under the provisions of the West Bengal Minor Mineral Rules 2002. Ito. West Bengal Minor Mineral Rules 2002. Yes. Huh? Was that? Yes. So, my lord, this is done in 2014. The affidavit your lordship was asking for us, from us, it is there in the deed. Page 94. Page 24. 94. Huh? 94. Page 94. That is, oh, yes, it is there. So, hindrance in the acquisition of surface rights of land adjacent to granite mine record full-scale operation. It is there, my lord. It is there. Now, even in your lordship sees the improved notice is dated 2014. 2014. And P5 is also 2014.
Yes.
2004. Now, by indicating this, my lord, the date of issue of this notice 2014, till that day you had your power 2002. Even beyond that day, you had your power. But unfortunately, your power was seized. You lost your power in 2016 because new law came, West Bengal Minor Minerals Concession Rules 2016. Concession rules? Wait. No, Joseph. Joseph. Yes. This is not marked, my lord, but however, Lordship kindly straightway goes to page 75. This is, first of all, I should show, my lord, your lordship. Kindly comes to, first of all, yes. My lord, it is the cover page, the Mines and Mineral Development and Regulation Act 1957. Thereafter, it starts the rules. The rules starts, yes. West Bengal Minor Mineral Concession Rule. Your lordship got it, my lord. 2016, your lordship got it. And notification number shown 2016. 2016, my lord. Your lordship got it, my lord. Yes. Where the draft notification to frame West Bengal Minor Mineral Concession Rules was published by notification dated so and so in Kolkata Gazette also, inviting objection and suggestions from the persons likely to be affected thereby within 15 days from the date of publication. And whereas, important, no objection and suggestion has been received by the state government. No objection has been received by this from the persons likely to be affected thereby within the given period. Now, therefore, in exercise of power conferred by subsection 1 of section 15, as subsequently amended, this rule is promulgated. The governor is pleased hereby to make the following rules. So it is again, on my lord, under the delegated power. This rule is framed 2016.
Yes.
Now your lordship goes to page 75 of that. Page 75 of that book.
Yes.
Rule 62. Rule 62. The West Bengal Minor Mineral Rules 2002 is hereby repealed. So it is repealed from the date of publication 29 July 2016. You lost your power. You cannot act. Cannot act. But you also kindly see sub-rule 2.
Yes, I've seen it.
Notwithstanding such repeal, with a non-obstante clause, my lord, it starts, notwithstanding such repeal, anything done, any action taken, or any prosecution started under the said rules, that is 2002, shall be deemed to have been validly done, or taken, or started, as the case may be, under the corresponding provisions of these rules. Under the corresponding provisions of these rules. Is there any corresponding provision in the 2016 rule? 2016 rule, that means your rule has been abolished. Lordship kindly goes to Rule 59. Rule 59. Rule 59, my lord. Your lordship sees. The matters not covered under these rules.
Yes.
Not covered under these rules shall be guided by the Central Act or the regulation and rules made thereunder.
Yes.
So, my lord, if it has to be looked into, then it has to be looked into under this act. Is there any provision of penalty? I mean, in my respectful submission, my lord, I have taken care of to find out if there is any provision in the new rule, in rule 35. Submit.
Yes.
The payment of royalty. The penalty ছিল। Yes. My lord, your lordship will kindly see. My lord, your lordship will kindly come to Rule 35 in order to be exhaustive, my lord. Rule 35 at page 66 of 2016 rule. 2016 rule. This is all with regard to royalty. All with regard to royalty.
Okay.
Nothing about penalty. The question of penalty was there in the 2002 rules, which has been abolished. And my lord, the new rule says, even if it was started, but that has, if there is nothing in the present rule, new rule, well, I do not know what we will see. It is a legislative flaw and the court is not going to fill it up. The question is whether your power.
Okay.
And you cannot do anything with regard to this because of the fact that the parent act, the domain, is of the central legislature. The central legislature has taken the reign. With regard to royalty and other things, okay. But with regard to payment of shortfall for extraction and transportation. I do not know for whose benefit it was made, my lord.
That's all. That's all.
I do not know for whose benefit this gap was there. I will not, my lord, I will not play any politics here. Though I have in my veins some politics, but I will not. However, if it is a legislative flaw and the domain being on the central legislature had intentionally, consciously, deliberately did not make any provision for a penalty for shortfall for alleged, my lord, extraction and transportation, your notice is totally bad. You cannot. Because it is the central law that will prevail and not the state law. More so when the state law has already been repealed without making any further provision. Although a provision has been made, that provision is with regard to the provisions made in the present rules, that is 2016. 2016, and when it was repealed, your lordship will kindly also note this factor that it was when the new rule was coming, it was publicized. There was no objection from the state.
That's
I believe my rights.
who is appearing for the state in this matter?
But I leave this book, my lord,
State who appeared for the state in this matter?
on 18th.
No, who appeared on for the state? There was nobody. Okay. For order से दिए थे किसी ने दिया तो देखे
Yes. ঠিক আছে। My lord, I am told Tulsidas Roy was appearing for the state and it was fixed in his presence. Your lordship fixed up this matter today in his presence.
No, he was not present on the last date. He was not present.
My learned colleague might have phoned him up, but there was no response.
কালকের আপডেট আসুন anybody from the state panel present in this court? Anybody from the state panel? So, give a notice to Mr. Roy to appear tomorrow.
For tomorrow.
I have heard you. If he has got any reply to the points of law, he is tomorrow. Heard, Mr. Yes, sir.
I am in the state panel.
You are junior to Mr. Roy. Heard, Mr. Amjad Ali, learned senior advocate, appearing for the petitioner. He concludes his argument. কালকে এটা কি টপে রাখা যাবে? দেখো তো টপে কিছু আছে কিনা? না কালকে অনেকগুলো আছে না? 9th রেখে দিচ্ছি 9th. None appears for the state respondents. List this matter on 9th January. Learned advocate for the petitioner is directed to come in, intimate the next date to the learned advocate for the state respondents.
May I
Just give. Yes.
May I, my lord, request your lordship kindly to fix it up a particular time because I have two matters fixed. Subject to your lordship convenience. Otherwise, let it.
ওটা টপে রাখো তো 9th কি আছে দেখো 11টার জন্য দিয়ে দেবো 9th কি আছে আরে top is top. On top, this will appear on 9th. You, Mr. Ali, you place the book on the next date you give. Acha, affidavit in reply filed on behalf of the petitioner is taken on record. Our affidavit of service filed by the petitioner is also taken on record. Thank you.
Item number 6,
Lordship, item number 6, I appear on behalf of respondent number 5, Lordship.
My lord, for the petition, my lord, my lord, the petition has to have the affidavit in reply, my lord. It is prepared, my lord, but due to the benefit of the petitioner's family, it could not be affirmed, my lord. My lord, I am seeking, my lord, 10 days.
So and so learned advocate for the petitioner seeks extension of time. Yes.
Lordship, this time has been extended on 3 occasions, Lordship.
Okay, let him come with the reply. কি বললাম? And the petitioner seeks extension of time to file affidavit in reply. Let such affidavit in reply be filed within a week.
Parent,
Yes.
10 days, my lord.
Within a period of 10 days. Please this matter. আজকে কত দিন? After 17th date বলে দিন 21st, huh?
Lordship, what time?
21st.
Not for
The
This is the third time, Lordship. Your Lordship had
Let's
initially.
say every 5 years. The aforesaid direction is made peremptory. 21st.
Item number 7.
That he has already reserved the affidavit in reply, which is filed by prisoner.
Lapse of proceeding.
Contains, yes. Private respondent. Here পৌঁছাতে পারলাম।
Finally, see the last order.
Hmm.
Last order passed by His Lordship, the Honorable Justice Onji Banerjee, my lord.
Who is for the state? State, anybody?
The Chandicharan Day is appearing. First order was 23rd December 2015. My lord.
Twenty-fifth August.
23rd December 2015. The first order one. The petitioner says that the state has asserted that the land described at paragraph number 2 of the petition has been acquired by the state in 1942, but the state cannot show any document in such regard. The petitioners also insisted that petitioner is the successor in interest of the owner in 1942 retained possession of 5.06 acre of plot of land, and the family has always been in possession of the land, at least since 1942. It is submitted on behalf of the state that the grievance pertains to the mutation of the property. Accordingly, the matter should be carried to the land reforms. The prayer made in petition is regarding the state's claim have acquired and lands which the petitioners may have discovered in course of revenue authorities rejecting the petitioner's application. However, since prayer made in present petition does not pertain to mutation but pertains to alleged acquisition of land by the state, the petition appears by the eminent maintainable in this court.
The petition will appear fortnight. Acquisition collector Krishnagor will file a report indicating the status of the land covered by the several DAG numbers. Paragraph 2, who is now in possession, land in questions and who has been in possession thereof for the last 20 to 30 years. But as per direction of my lord, the state, my lord, submitted the report. My lord, can you see the opposition filed by respondent of 1, 2, 3, 4 and 5. My lord, in the para 9 of the opposition filed by the state, they disclose who are the possession of over the land.
There is also private respondent.
They are claiming that they are in possession, they are occupying the land. They made application for addition of party.
Give a notice.
They are also appearing.
Asun,
In their presence, the date was fixed.
give a notice. অসুবিধাই হয়ে যাচ্ছে স্টেটের অ্যাডভোকেট নেই কেউ নেই ডিফিকাল্টি সীমাহীন হয়ে যাচ্ছে None appears for the state respondents. Top. The added respondents are also unrepresented. None an advocate for the petitioner is directed to serve a notice upon an advocate for added respondents as well as state respondents intimating the next date of hearing. Is this matter on date বলো I don't know. কবে 17টা দিয়ে দাও 17th দেখো 14th give a notice to the added respondents and plan an advocate for added respondents and state
Fixed on
14th.
Good.
কি হলো কি হচ্ছে কোনো লাভ হলো না You have completed?
Almost. I thought my learned friend is finished. I am all ready, Mullah, to argue my side now.
I am literally I don't know whether I need to write another judgment or not. Only to that extent. And my lord was pleased to put a query to us whether with regard to the termination.
The records you have produced.
Record we need to bring the original record. We have scanned those records. The original record there was no revision of this. That's why the original records were presently could not be located. We require 4 days time to find one.
Then along with the original records, you also produce a true copy of all the documents. I mean the records, which should be kept with the record. 4 weeks, it's a long time.
The change of officer, the shifting of division office, that is the main problem. At the point where find the application, those records are other. Now it's in this is shifting of section office.
Yes, you complete your argument then. Today you complete your argument, on next day you will produce the records. After inspection, you will make his reply.
Yes. Otherwise, no point in.
I'll provide a citation to Mr. Banerjee before.
Then you are not raised it.
I'm still in a dilemma whether to cite a judgment to or.
Find out what is the judgment favorable for you. Ashun.
21st
Record
August
to
was one of my last submission. And that's whenever Malad they produce it, then Malad I've been make us.
Make it within first week of February.
Very good.
Not try. Just ask your officers to scan and get a true copy of that and file it because Mr. Saurabh Mukherjee, learned advocate for added respondent number 7, seeks accommodation to make his further arguments. Learned advocate for respondent number 126 IOCL seeks some more time to produce the records of the proceedings in respect of termination of dealership of the petitioner pursuant to order dated 19th in terms of order dated 19th December 2024. Let such records along with true copy of the records be produced before the court. After original court, let such original records along with true copy of the record shall be produced by respondent number 126 IOCL on the returnable date. February month first week in 5th, 6th. Please this matter on 6th February. 6th.
So this is my Lord's pleasure, Malad. Any time Malad may be fixed because since they're going to produce the
6th February the topic, 2 p.m. Can Thursday though?
Thursday.
Thursday. First top হবে না টপে হবে না top.
I'm great. Good. I'm so good. And Malad, if they give us Malad an advance copy, then we'll come ready. And I want to Malad not take Malad further time. I'll just try to issue the Malad on that.
Under assigned matters topic. না থাক না গুগল কম দিবে Not today. Not today.
Find out one thing, not today means today, tomorrow. My brother's son ceremony.
Ask your junior to remain present.
I
Not
have
the other advocates have.
informed Mr. Lokhi Gupta, informed Nondi.
Let it come up tomorrow. Ask some of your junior to remain present and inform the court about your predicament.
Tomorrow, day after tomorrow, Thursday.
Sir, ask your junior to remain present tomorrow. They have left the court.
My brother expressed, that is my problem.
Okay, you ask your junior to inform the court about your predicament. That's all. একটা ছিল না টপের যেটা কালকে হবে তাহলে থ্যাংক ইউ
Deed be granted to the sub side.
It will be mentioned in the calculation.
Matter is achieved. As followed.
Item number?
Monthly.
ठीक है, wait. Yes.
May I have, my lords, kindly to renew my prayer in the morning, which I was making, my lord. It's for enlistment. My lord, it's GA5, my lord, GA5 of 2024 in the matter. My lord, this is the mentioning slip, and this is the last order. He was granted, my lord, for amendment. We have, I'm only praying that it be enlisted.
Yes. Clear to clear.
GA5 is the amendment application.
Leave is granted. Leave is granted for
the amendment application, that is GA5. So I'm only praying that be listed. It's amendment of cause title, my lord. It's a formal amendment. Nothing else.
GA5 is the amendment application.
For amendment of the
and
cause
leave
title.
is granted to amend that application.
No, my lord. Leave is granted, my lord, that the amendment be carried out. So, my lord, the application has to be listed. It was not listed thereafter. So, I'm only praying that the application, once it is listed, it's a formal, my lord,
okay,
amendment, and then, my lord, it can be proceeded with. The matter can be proceeded with.
Yes, it does not relate to intellectual property.
No, it doesn't.
List.
Lord, may I only pray tomorrow? I mean, I'm not in town, my lord. Any other day other than tomorrow, my lord. Any other day.
Next week, Friday.
Friday. Very deeply.
Next Wednesday.
Next Wednesday, I'm very deeply obliged.
Original say daily list item number 1.
For the applicants, this application has been taken out by the legal heirs of the plaintiffs. It's number 3. The suit was this application leaves. One of the prayer is that taking leave for service upon the opposite party, because the suit was treated much earlier in terms of settlement. I am the legal heir. Prayer 3, in terms of prayer 3,
petitioners
granted to some copy of the legal heirs of the other side. All are dead.
Who are dead?
Plaintiff number Mahabendu Kundu, dead. Wife. Plaintiff number 2, Ashok Kumar Kundu, unmarried, died. Raghunath Kundu, I am the legal heir of Raghunath Kundu. Wife and son.
And legal heirs of the other plaintiffs?
That may be paid for leave to sub copy to the other legal heirs of the other dependents. In terms pair C, my lord.
Why dependents? Why not plaintiffs?
Plaintiffs, there is only 3 plaintiffs.
Who are the legal heirs of the other deceased plaintiffs?
My lord, paragraph plaintiff number 1 was issueless, died. Plaintiff and his wife also died. Plaintiff number 2, unmarried, died. No issue.
Yes, stated.
Unmarried. And plaintiff number 3, I am the son and wife of plaintiff number 3.
One has died, and his wife has also died. Where have you stated?
But 41, my lord.
Page?
Page 41 is the death certificate. Page 41.
In the application, you have not stated.
Yes, my lord.
Which paragraph?
Page 8, paragraph 8.
Okay.
State Mahabendu Kundu was childless and died intestate on 9/7/2015, and his wife also died. And Ashok Kumar Kundu, the plaintiff number two, unmarried, died.
Application D3.
And the applicants before your lordships are the legal heirs of the plaintiff number 3.
Where is the order passed in GA1 of 2024?
Page, my lord. At that time, the address of the legal heirs of the defendants was not ascertained. That's why matter was withdrawn.
Now you have got the addresses.
But and handed to some of the legal heirs of the
This is an application for appointment of the petitioners and other trustees to jointly act as trustees of the Devottor estate. Para Mr. So-and-so, learned advocate for the applicants, submits that all the plaintiffs have already expired. Plaintiff number 1 and his wife has expired issueless. And plaintiff number 2, নামটা নিয়ে নিন, one হয়েছে মাধবেন্দু কুন্ডু, plaintiff number 2 Ashok Kumar Kundu has died a bachelor. The applicants being the legal heirs of deceased plaintiff number 3 Robindranath Kundu has filed the present application for proper management and administration of the Devottor estate. He also indicates that previously an application being GA1 of 2024 was filed, but since the service could not be effected, the application was withdrawn. He seeks to serve copy of this application upon, he seeks leave karo. Serve copy of the application upon the surviving descendants of deceased defendants, more fully described in paragraph number 18 of the application. Leave granted. Let there next line go. Let there be order in terms of prayer C of the notice of motion. Learned advocate on record for the petitioner is directed to file affidavit of service on the returnable date. Release this matter after 3 weeks.
Item number 2.
My application.
Directly for the state has one.
This is the affidavit of service. But this is really in aid of an order that was passed earlier. The joint receivers have been appointed. Joint receivers are party receivers. There was an order that was passed by this honorable court. Order that was passed by this honorable court, allowing us to sell certain properties. So we've identified somebody. Your Lordship will forgive my the voice is a little late today. But we've identified a few people. One such person was Mass Services. So they were identified. We had come before this honorable court. This honorable court had directed them to deposit certain amount of money in aid of that sale. Now, Mass Services deposits, their check bounces, and there the joint party of receivers have also cancelled that sale in their favor. Now we've identified someone else. I'll just show those two orders. Lordship will allow us to sell the property to the second purchaser that we've identified. That's all that the application purpose. state is appearing today. I'm hoping they will not take any.
It has always been the Lordship knows in this matters relating to Kundu Chaudhary, it is the contention of the state that the lands have vested to the with the state. At the order, that was passed in that is at page 108, perhaps, which is my learned friend is referring to. That was passed when the state was not represented.
Very well.
Subsequently, we had made an application that is GA 238 that is not appearing in the list, by which we were allowed to appear as a party.
Maybe.
Yes,
The
on
state is
several
not
applications,
state is not a privileged litigant here. State had come and taken time to file this affidavit on the same pretext on 29th of January 2024, 1 year back. And the state does nothing. State has nothing to show this is vested, because I'll tell you, Lordship, why. This property comes under Howrah Municipal Corporation. Now, knowing Mr. Shahu, I'm sure he understands that when it comes under the corporation, there's no question of this being vested. There's a plot number 140. This court has applied itself to this plot, to the address. State has taken 1 year, has not come forward with any affidavit. There's not one scrap of document to show that this is vested. At least this plot of land, there is no vesting. It's under HMC today. And I'll show that order,
There is an order, previous order. I'll not ask for more indulgence. Lordship will kindly give me 2 weeks time. If we can file an affidavit, well and good. If not, Lordship will proceed.
They didn't even take, and they didn't mention the matter to seek extension of time. At my insistence, when the matter comes up,
taken up for the last
we
have
got the matter taken up. No, last time they didn't even appear. We had to serve them again. That was just before the vacation. No, I'm opposing this for 1 year. A party doesn't file affidavit and treats it as a matter of course.
Mr. Learned advocate appearing for the state seeks extension of time to file affidavit in opposition. Mr. Shuddhasatya Banerjee, learned advocate appearing for the applicant, submits that the state was directed to file affidavit in opposition in the month of January 2024, and thereafter no such opposition has been filed. He opposes the prayer for extension of the time. Considering the prayers, the state is directed to file its owner submission for extension time. He also indicates that the land proposed to be sold out is a vested land. In view of the considering the above, the state is directed to file its affidavit in opposition within a period of 2 weeks. A reply, if any, be filed within a week thereof. Is this matter after 3 weeks?
Could I have a returnable date on which I could come back?
Khabe asche 3 weeks pore?
Returnable period is nothing.
Great, clear.
Item number 3.
Well, this is my application. Application by the defendant numbers 2A to 2H. My lord.
Where is the receiver?
The plaintiff, my lord.
My lord, we had served on the learned advocate for the receiver on 23rd of December, my lord.
May I seek leave to file 2 replies, which was already served on them. After addition of party, and the other is in respect of the supplementary file.
5 is your application.
5 is my application, my lord.
And what is the other one? 2 replies means?
GA8, my lord. The
GA8 is your
an
application.
Addition of party application in the same suit, my lord.
GA8 is a different matter, my lord. It's an application for addition of party. Today we are concerned with GA5, my lord, which is an application taken out by defendant numbers 2A to 2H, my lord, for discharge of the receiver.
Okay, you file a reply with in respect of GA5 because 8 is not appearing.
I have filed the reply to the supplementary affidavit.
Okay. Supplementary টাও দিয়ে দিন।
There was a supplementary affidavit to which we filed a reply.
দেখি কপিটা দেখি। তোর কাছে কপি আছে? সাপ্লিমেন্টারি আছে?
Rejoinder to their opposition. Rejoinder to their opposition.
এটাই তো।
Upon the
9th of February.
Yes, yes.
It's a,
Not
Madam, it's a
supplementary affidavit.
rejoinder to the reply because there were certain additional documents in the reply.
All right, I'll just indicate in my against my application, they filed an affidavit in opposition where they did not deal with certain allegations. So I took the point of non-traverse in my affidavit in reply. To cover that, they are filing another affidavit. They're naming it as an affidavit of rejoinder. I have received it. I do not have any objection to it. It may be taken on record, but there is no supplementary affidavit.
So, what is the nomenclature of this affidavit? Affidavit in reply?
I have indicated it as the affidavit in rejoinder on behalf of the plaintiff.
Whether my lord will take it on record or not, kindly sees there was no direction for filing such affidavit.
I only intend to rely on an
They should
order.
seek, at least they should seek leave, my lord, before filing such
Because,
affidavit.
my lord, I need to file an order, bring on record one particular order of this court passed in the same suit on 29th of January
এইটা
2024.
কোনটা এই বাবু অঞ্জন বাবু উনি
It's
কোনটা
an
পাইছেন
affidavit
মিস্টার দাস
formed on 9th of February
এইটা rejoinder,
2024. Filed in January 2025.
হ্যাঁ his client
If I
is
may indicate, my lord, this is a application which has been filed for recall of an order. My lord, this same application for recall of the same order, there were two previous applications which were filed and dismissed. The second of such dismissal was on 29th of January 2024. My lord, that order, I'm just indicating.
None of the prayers of my application
I'm
seeks
just
recall.
indicating, my lord,
It
this
is not
order was
recall.
passed on 29th of January, which is why on subsequently I have to bring it on record.
right. Yes.
My lord, the learned receiver is also being represented. My learned friend is appearing for the receiver, my lord. My lord, I am seriously opposing this prayer. This application was filed in April 2022. Total 10 adjournments given. My lord, affidavits have been completed. My lord will see the last 10 orders. My lord will see. I am opposing this prayer, my lord. If he is being represented, I do not understand why his affidavit is on record. May I place my application, my lord? My lord, in this application, I have played for discharge of a receiver on certain grounds, my lord. Now, before I go forward with the grounds for discharge of the receiver, kindly sees what is the suit for. The suit is for specific performance of an alleged agreement for sale of an immovable property. That property, my lord, is situated outside the jurisdiction of this honorable court. One of the grounds on which I am seeking discharge of the receiver is that in the suit, the only prayer is that of specific performance, that is by execution of a deed of conveyance. There is no prayer with respect to possession of the property that has been sought. In fact, it could not have been sought because had that been sought, my lord, then this suit would have been barred because by virtue of absence of territorial jurisdiction. Now, the receiver was appointed in the year 1987. Today, my lord, my biggest, the best case that my learned friend or the plaintiff can make is that if the suit is decreed, then he will get a deed of conveyance in his favor. But then who will the receiver return the possession of the property to? The plaintiff or the defendant? Because the plaintiff has not sought for possession, the receiver cannot return the possession back to him. So either the receiver has to continue indefinitely or has to return it back to me. I am humbly submitting that since there is no relief of possession sought for in the suit, my lord, the receiver could not have been appointed. It had been appointed, does not matter, but he can still be discharged. Kindly takes the plaint once. It is annexure A to my application.
You are in the suit. You are.
I am defendant numbers 2A to 2H, who are the legal heirs of the original defendant number 2. Original defendant number 2 was the owner of the land. He passed away. His legal heirs have been substituted. My lord, I have come into their picture, my lord. Kindly sees, my lord, the plaint. Because from the plaint, my lord, will get details of all the parties. It begins at page 23 of my application. Annexure A. Because this is a suit for specific performance, my lord, the readiness and willingness will also be an aspect. and till date the trial has not commenced. Issues have not yet been framed. The plaintiffs have not taken any steps for that. Kindly see, it's a suit of 1987. The plaintiff Rajendra Kanodia had instituted the suit against one Mahendra Prasad Bansal and number 2, whose name has been struck out, my lord, Lokhi Narayan Dhar. Now, Lokhi Narayan Dhar having passed away, my lord, his legal heirs, 2A Srimati Lakshmi Dhar is the wife, and 2B to 2H are the children of Lokhi Narayan Dhar. They have been substituted, my lord. Kindly sees, the plaintiff states, page number 24, para 1. By an agreement in writing dated August 20, 1986, one Lakshmi Narayan Dhar, since deceased, and being the original defendant number 2, agreed to sell to the defendant number 1. So, defendant number 1 is Mahendra Bansal, Mahendra Prasad Bansal, agreed to sell to the defendant number 1, and the defendant number 1 agreed to purchase from the defendant number 2 a piece and parcel of land measuring 2 bighas or 66 decimals situate within Pargona, Boikunthapur, Mouza, Dabgram, Police Station, Bhaktinagar, SR Office and Subdivision in the district of Jalpaiguri, outside the aforesaid jurisdiction more fully described in the schedule. So, the suit property is admittedly outside the jurisdiction of this honorable court. No suit was instituted in where the situs of the suit property is situated. It has been instituted before this honorable court. Now, my lord, paragraph 2 talks about the, my lord, terms. Now, kindly comes to paragraphs, my lord. In paragraph 3, that stated, in accordance with the terms of the said sale agreement and in compliance thereof, the defendant number 1 duly paid to the original defendant number 2 rupees 50,001 rupees as and by way of earnest money. 4. Subsequently, it was agreed by and between the defendant number 1 and the original defendant number 2 at number 1 Mango Lane in the town of Calcutta within the aforesaid jurisdiction. That is how they are trying to attract the territorial jurisdiction of this court, that the balance consideration money for the sale in respect of the said property will be paid to the original defendant number 2 at Calcutta, and the defendant number 2 shall execute and register the necessary sale deed in respect of the said property in favor of defendant number 1 and or the person or persons nominated and or recommended by the defendant number 1. So far, my lord, there is pleadings in respect of an agreement for sale being entered into between defendant number 2, who was the owner of the land, and defendant number 1. Now, my lord, paragraph number 5. Pursuant to the said sale agreement as aforesaid and in terms thereof, the defendant number 1, by an agreement dated March 16, 1987, duly nominated and recommended the plaintiff for the purpose of completing the purchase of the said property from the said original defendant number 2. So, defendant number 1 suddenly decides to assign his right under that alleged agreement of sale in favor of the plaintiff. Defendant number 2 was not a party to it. On that basis, my lord, thereafter they go on pleading that they had applied for the conveyance to be made, but no such conveyance were made. Paragraph number 11 at page 27 says that the plaintiff had performed and has always been ready and willing to perform the terms of the aforesaid agreement which were performed by him. The plaintiff is entitled to and claim specific.
Now, who is defendant number 1 here? He's a purchaser.
Defendant number 1 was the person who entered into an agreement for sale with defendant number 2 to purchase the property.
Okay.
So, defendant number 1 was the agreement holder, if I may use that term.
Okay.
Now, defendant number 1, the plaintiff's contention is defendant number 1 assigned his rights under such alleged agreement for sale to the plaintiff. On that basis, the plaintiff is seeking specific performance of that agreement against me, the defendant number 2, rather the legal heirs present. Now, kindly sees paragraph number 13 by which the cause of action has been pleaded. Inasmuch as part of cause of action as stated paragraphs 4, 5 and 8 herein above has arisen within the jurisdiction of this honorable court, and inasmuch as a part of the cause of action as stated in paragraph 1 herein above arose outside the jurisdiction aforesaid, the plaintiff plays for leave under clause 12 letters parent to institute the suit. So, my lord, if my lord goes back to paragraphs 4, 5 and my lord 8, my lord will see that they are saying that the agreement for sale was entered into within the territorial jurisdiction of this honorable court, and the paragraph number 1, which is outside, my lord, the suit property is admittedly outside. So, on this basis, my lord, now kindly sees what reliefs they have claimed at page 28. The plaintiff prays for leave under clause 12 of the letters patent and claims a decree for specific performance of the said sale agreement dated August 20, 1986 by directing the defendant numbers 2A to 2H to execute and register the conveyance in respect of the said property at measuring 2 bighas or 66 decimals situate within such and such place, Jalpaiguri, more fully described in the schedule to the said sale agreement. B. In the event of failure or refusal by the different numbers 2A to 2H to specifically perform the said sale agreement as referred to in prayer A above, the registrar original side High Court Calcutta be directed to execute and register the necessary conveyance. C. Damages. D. Receiver. E. Injunction. F. Costs. G. Further and other reliefs. So my lord will see that there is a conspicuous absence of any relief with regard to possession of the property. Possession was admittedly with the owner of the property. There is no averment made in the plaint that the plaintiff was in possession. Now, under such circumstances, my lord, an application was filed and moved ex parte, and my lord, an order was passed appointing a receiver over the suit property. My lord will find that order
Yes.
My lord will find that order.
One thing, my learned friend is submitting on merits of the application. I am not coming in the way, but my lord, the maintainability of the application is something I will be arguing. My lord, if he so intends, he may address it at this stage while he's taking my lord through the entire merits of the matter as well.
I'll do everything at one. No piecemeal argument. My lord will kindly seize the order appointing the receiver at page 32. Mr. Ashok Kumar Mitro, an advocate of this court, is appointed receiver in terms of prayer A of the petition. He will be entitled to a remuneration of such and such to be paid by the petitioner. There will be an ad interim order in terms of prayer B of the petition, returnable on such and such date. So, my lord, by this, my lord, the receiver was appointed over the suit property. Now, prayer B, these petitions are, I've tried for finding out this petition, tracing out this petition, but it's not available. Prayer B, my lord, is respect of possession of the property. That, my lord, will understand from page number, the next page, page number 33, which is the minutes of the receiver by which he has taken possession of the property. Kindly seize the minute, my lord. On 20, may I place the minutes, my lord? On 26th of May, 1987, Mr. Mahendra Prasad Bansal and Mr. Rajendra Kanodia.
Pagination is wrong.
My lord?
The application's pagination is wrong.
Pagination?
Yes. Your 33 is 32 in the application. You are referring to 33.
My lord, the minutes is at in page 33, my lord.
Oh, see, it is 32. Can we take a look?
I'll just kindly give me a moment, my lord. তো তোরটা তোর সাথে মিলছে? I'm so sorry, my lord. The correct pagination is because there are two page number 22s. That's why, my lord. My lord, address.
There are 222.
Well, at this page 22, the next page. May I correct that, my lord? Or I can address by the page numbers that is appearing in the brief.
No,
my lord.
whenever you say, I will just deduct one.
My lord, no. I will deduct one and I'll say, my lord. Kindly comes to page number 32, my lord.
32.
Page
Yes.
number 32 is the minutes, my lord. Kindly seize. On 26th of May 1987, Mr. Mahendra Prasad Bansal and Mr. Rajendra Kanodia. My lord will kindly note, Mahendra Prasad Bansal is the defendant number 1 and Rajendra Kanodia is the plaintiff. Took me from hotel. We came to 2nd Mile, Sevok Road, Mauza Dabgram, PS Bhaktinagar, District Jalpaiguri. On reaching there, we meet Mr. Mahendra Prasad Bansal. Both Mr. Kanodia and Mr. Bansal identified the disputed land. None on behalf of Lakshmi Narayan Dhar are present. Although the notice of my taking possession of the said land duly have been intimated to the parties on 25th of May 1987. Mr. Kanodia requested the receiver to affix a board in the disputed land that the receiver has taken possession of the same as per the order of the Honorable High Court. Accordingly, a board has been affixed within the said land through wooden structure. Mr. Kanodia, Mr. Bansal, Mr. D.K. Subba, the guards of Sri Lakshmi Narayan Dhar, taken photographs along with board affixed on the said land. We waited to the land for Sri Lakshmi Narayan Dhar up to 11:15 a.m. After taking possession, I left for hotel at about 11:30 a.m. The things that can be culled out from this document, my lord, is number one, Lakshmi Narayan Dhar was absent despite notice. Number two, possession was taken on 26th of May. On 26th of May 1987, and my lord, the guards of Lakshmi Narayan Dhar were present. So, my lord, from this, it is palpably clear that the possession of the property was with Lakshmi Narayan Dhar, the defendant number 2. Otherwise, there would be no prayer. If the plaintiffs were in possession of the property, there would be no requirement for any receiver to take possession. Why would they, being in themselves in possession, appoint a receiver over that? Now, my lord, the picture will, my lord, find at the next page at page 33. So, my lord, the pictures was taken, this date was, this is corresponding to the minutes. Now, my lord, the personnel of the...
My lord, at least the one that I have received. The picture is an illegible copy.
I'm not relying on the photograph. So their receiver, they should be having a copy of the report. Let them furnish the report with a legible copy.
Application, my lord. The addressing, my lord.
Very well.
It was illegible, which is what I was pointing out.
Now, my lord, the personnel of the receiver was subsequently changed. And this we have come to know from, my lord, a paper publication which was made. Page number paper. Kindly seize, my lord, page number 97. 98 na paper publication. Newspaper. Yes, my lord. Page number 97, my lord, is a typed copy. The original one is at page number 98. I'm reading from the typed copy itself. Or if my lord wants, I can read from the actual publication also. My lord, this was a publication on, my lord, yes, 3rd of December 1987. 3rd December 1987, my lord, will see right at the top, my lord, of the newspaper publication at page 98, the typed copy of which is at 97. It says, my lord, 3rd December 1987. It's in Bengali, my lord. I'm placing the new publication, my lord, by the new receiver who was appointed. Suit number 451 of 1987, Rajendra Kanodia versus Mahendra Bansal and others, now pending before such and such justice at the High Court at Calcutta. This is for all concerned that the above suits pending before the Honorable Mr. Justice A.K. Sengupta of the High Court at Calcutta and his Lordship was pleased to pass certain directions on 20th May 1987, whereby the defendants to the suit property were restrained to transfer and dispose of and or alienate or encumber the scheduled property as mentioned herein below. Subsequently, on 2nd of June 1987, the undersigned has been appointed as receiver instead of Mr. Ashok Kumar Mitra, Advocate, Calcutta. So initially Mr. Ashok Kumar Mitra was appointed. Subsequently, the personnel of the receiver was changed, and Mr. Milan Sarkar, an advocate who practices in Jalpaiguri only, based in Jalpaiguri, was appointed as the receiver. Further, upon the report of the undersigned, his Lordship Mr. A.K. Sengupta was pleased to direct further to construct boundary wall by the petitioner for the safety and protection of the land in question. So the land in question was without a boundary wall. For preservation, a boundary wall was directed to be constructed. The undersigned was also directed to publish the gist of all orders as stated above in Uttarbanga Sangbad. Hence, this notice is given to all concerned claiming any interest over the land as specifically mentioned in the schedule given herein below. Schedule of the suit land, all that piece and parcel of land measuring 2 bighas or 66 decimals, and then the particulars given, and right at the bottom, my lord, it's written Milan Sarkar. So, my first limb of argument is that admittedly, when the suit property is outside the territorial jurisdiction of this honorable court, whether the plaintiff succeeds in the suit or the suit gets dismissed, who will the possession be returned to? Has to be the defendant. Now, unless there is some apprehension expressed that I am because there is already an order of injunction preventing me from transferring the property. Now, until an apprehension is created that I am putting certain other people in possession, even that there is an injunction, there was no necessity of a receiver. The receiver has been continuing from 1987 till date. Now, my lord will say that why after such a long period of time you have come for the discharge of the receiver. It is only, my lord, for the point that a receiver could not have been appointed in respect of a property which is outside jurisdiction. If they had filed if there was a relief of possession in the suit, I would have understood that the receiver is for the purpose of protecting the possessory rights of the parties in respect of the property. But the suit is simpliciter, a suit for specific performance of an agreement which was allegedly entered into within the territorial jurisdiction of this court. If they succeed in the suit, then they should seek possession in a proper court. Whether it is section 16 of the Code of Civil Procedure, my lord, or it is clause 12 of the latest patent, my lord, this becomes a suit for land the moment possession is sought for. So to escape, to come out of that, my lord, no possession has been sought for. If no possession has been sought for, a receiver cannot be appointed today in respect of an immovable property. Now, my lord, second, so my lord, one of my prayers in the application that I have made is for discharge of the receiver and for giving the possession back to the defendant numbers 2A to 2H. Because my lord sees kindly, till date, we continue to be the owners of the property. The suit has not yet been decreed. The plaintiff at best can contend that he is an agreement holder, or rather the nominee of an agreement holder. So the possession should remain with the owner, my lord. Today, since 1987, for more than 38 years, I have been kept out of possession of the property. I could have earned from the property. I could have put in tenants, I could have used the property, I could have earned from the property, but I am out of possession. Now, secondly, my lord, will kindly take my application.
Now, the appointment of receiver, the ground you have taken.
Yes, my lord.
That the appointment of receiver should not have been made.
My
That
lord.
is, would have been pressed before a division bench against the order of the single bench.
My lord.
Now, whether this court can go into this, whether the appointment of the receiver was correct, what was the legality behind that, that cannot be gone into.
I am not seeking, my lord, to sit over in appeal, my lord, over an order earlier passed by a single bench, my lord. I am not doing that. I am not challenging that order. That is why I have not sought for recall of the order. Today, my lord still has the inherent jurisdiction to discharge the receiver today. My lord has the jurisdiction to pass an order of injunction today and vacate it tomorrow. Similarly, my lord, I am seeking that an appointment was made today, the discharge should be made. I am not going into the legality or illegality. Kindly seize a balance, my lord, of equities. Today, an owner has been kept out of possession for 37 years when the plaintiff, who's stated in the plaint that he is ready and willing to perform obligations under the agreement, has not even proceeded with the trial of the suit. And for 37 years, despite being the owners of the land, I am kept out of possession. Is the plaintiff at all serious? On this basis alone, my lord, the receiver should be discharged. Let them fight out the suit. If they get a deed of conveyance, then they can ask for possession, which in any event they have not in this suit. Now, my lord, second thing. Why I say, my lord, the plaintiff, the defendant number 1, and the receiver, I would also respectfully submit, are hands in glove with each other. That, my lord, will find, kindly sees, takes my application, my lord, paragraph 22 at page 11. Because I have some serious allegations against the receiver and they stand admitted through documents, documentary proof. Kindly takes paragraph 22 at page 11 of my application.
Yes.
Your petitioners have recently discovered that the receiver, that is Sri Milon Sarkar, also known as Sri Milon Krishna Sarkar, is a director of Terai Tea Company Limited. Kindly marks the name of this company, my lord. He is director of Terai Tea Company Limited. The plaintiff, that is Rajendra Kanodia, is also a director in the said Terai Tea Company Limited, Obhijit Tea Company Limited, and Terai Infrastructure Private Limited. In this regard, relevant documents evincing that the receiver and the plaintiff to be directors in the same company is annexed here to and marked J. I will take, my lord, through these documents. In this regard, the master details of the aforesaid companies obtained from the website of the Ministry of Corporate Affairs are collectively annexed here to and marked K. There is a genuine conflict of interest in the present receiver continuing to act as an officer of this honorable court in holding on to the possession of the said property, especially since it is manifestly clear that the said receiver is also a director in a company wherein the plaintiff is also a director. Furthermore, such fact was neither intimated or informed to your petitioners or this honorable court by the present receiver or the plaintiff, and the same tantamounts to willful suppression of material facts. My lord, an officer of the court is supposed to be a neutral person who's supposed to be in the custody of a property. The property is a point of conflict or dispute between the parties. None of the parties would want the receiver to side with any of them. So today when I find out for 10 years, the receiver is a director in a company with the plaintiff and they know each other, they're acting as the same board of directors of the company, and I will show what further acts has been done. There is definitely a conflict of interest. Under such circumstances, this receiver cannot continue. This is in alternative to my first relief, my lord, where the receiver should be discharged and my lord, possession should be handed over to me. And in the alternative, my lord, some new person should be appointed receiver instead of the person who's presently continuing. Now, my lord, I will show the documents, my lord. Those documents start from page number 99. Kindly sees. Page 99 is the master data of Terai Tea Company Limited. The name of the company is mentioned on the second line, top middle portion of the page, Terai Tea Company Limited. The date of incorporation of the company is 25th of September 1973. Kindly turns the page over, page 100. Kindly sees Rajendra Kanodia, director's signatory details. They all have their DIN and PAN number, director identification number, and my lord. So my lord will see item number 2. Rajendra Kanodia, who was appointed on 28th of January 1987 and subsequently again on 30th of May 2014. Serial number 2 and 3, my lord, written in all caps. Now, my lord will kindly see the second last name from that list. Milan Krishna Sarkar, 26th of July 2014. And from the affidavits, I will show that there is no identity crisis. This gentleman is the same gentleman who's the receiver. Now, my lord kindly turns the page over to page number 101. This is, my lord, a printout from the information given in the website of Terai Tea Company Limited. Kindly see, the group is run by board of directors. So the entire plaintiff group of companies, the plaintiff Rajendra Kanodia is a director in such group of companies. The group is run by the board of directors having majority of the professional directors who are expert in their respective fields. The group companies have common directors in most of the cases. The gardens and units are managed by their respective heads. A. Board of Directors of Terai Tea Company Limited. Kindly comes to ignore 1 and 2 and kindly comes to 3 and 5. 3. Mr. Rajendra Kanodia. He is the group director and the CFO of the company with huge experience of over 25 years in marketing, administration, and financial management. 5. Sri Milan Krishna Sarkar, he is a senior practicing advocate with high reputable image in the legal world. The company can profit from his legal background in acquisitions of tea gardens and other properties, which he is highly competent to undertake easily. It's very unnerving for the defendants to notice that the adversarial party, the plaintiff, and the receiver have been jointly working since 2014. My lord has seen that page number 99, page number 100, where my lord Milan Krishna Sarkar has been a director since 26th of July 2014. So my lord, for the last 10 years, they have been working together on behalf of a company, and they did not think once to inform this honorable court or to seek his own discharge that I want to work with them, kindly appoint somebody else. There's been complete suppression for the last 10 years, my lord. It is only after we found out that we had written letters to various parties, my lord, that is when we have come to find out. Now, my lord will kindly come back to my application, the averments in my application, paragraph number 24. There were a series of transactions that company and Rajendra Kanodia and the receiver tried to do with the suit property, which I was finally able to stop. But the modus operandi is quite clear. Kindly sees, my lord, paragraph 24 at page 12 of my application. In any event, the present receiver has acted beyond the scope of the order dated May 20, 1987, and the same would be evident from the following facts. A. One Ajit Kumar Agarwala, Terai Tea Company Limited, Obhijit Tea Company Limited, and Terai Infrastructure Private Limited had jointly submitted an application on July 7, 2021 to the Shiliguri Jalpaiguri Development Authority Shiliguri for grant of land use compatibility certificate under section 46 of the West Bengal Town and Country Planning and Development Act, along with a site plan, by amalgamating the said property meaning the suit property herein, my lord, the said property which is in possession of the receiver and other plots of land belonging to Terai Tea Company Limited and Terai Infrastructures Private Limited, by suppressing the facts relating to the pending litigation with the respect to the said property. So, my lord, an application was filed for amalgamation, the suit property with several other adjacent plots. All these adjacent plots are owned by, my lord, the Terai group of companies and, or, my lord, their directors. So they want to amalgamate into a whole plot of land. What we have understood now, they want to raise a shopping mall there. Only my plot of land, which is still the subject matter of this suit, where receiver is appointed, is not within their ownership. Despite that, and the receiver is appointed over it. Despite that, they applied for getting all of them amalgamated. LUCC, my lord, is my lord, one of the steps for getting, my lord, sanction for construction of a building, my lord. It is needless to mention that the present receiver, being the director of Terai Tea Company Limited, is deemed to have knowledge of such an application being made inter alia on behalf of the said company. Such an application was made after the receiver became a director of the Terai Tea Company Limited. Your petitioner has come to know of such a fact from a letter dated March 14, 2022, issued by Shiliguri Jalpaiguri Development Authority in reply to an application made by your petitioner number 2D under the Right to Information Act 2005. Your petitioners have also obtained copies of land use compatibility certificate and site plan submitted by the aforesaid persons before the Shiliguri Jalpaiguri Development Authority. In this regard, a copy of the application under the Right to Information Act 2005 reply and the land use and compatibility certificate and the sketch plans are collectively annexed here to and marked L. Now, my lord will kindly see this particular document. My lord will find at page number 105, my lord. This is the RTI that was issued, my lord. Kindly sees it's a letter dated 9th of December 2021 at page 105.
Yes.
I hereby request you to please supply me the information under the Right to Information Act in respect of the land utilization computability certificate purportedly have been submitted in respect of the below scheduled land within ward number such and such under Shiliguri Municipal Corporation, which is required for the purpose of determining the issue in a pending proceeding before the Honorable High Court. Who has submitted the application for LUCC in respect of the land under schedule mentioned in ward number such and such under Shiliguri Municipal Corporation? When was the application submitted? Please mention the date. Please provide me the names and other details of the persons who have submitted the application for LUCC along with the site plan. Please also let me know my present status of the application, if any, submitted as aforesaid, whether the application for issuance of LUCC as aforesaid has already been granted or is it pending for approval. Please provide the detail. LUCC already, if any, has been issued. Please supply me the certified photocopy of the same. Did Shiliguri Jalpaiguri Development Authority receive any complaint in respect of the below mentioned scheduled property? If yes, please supply me the copy of the action taken report. Please supply me the certified copy of the site plan in respect to the below scheduled land property as aforesaid, if any, received by the Shiliguri Jalpaiguri Development Authority along with the application. Now, my lord will see all that piece and parcel of land recorded in RS Khotian number 569/01 comprised in plot numbers 237, 238 and 238 by 832 of Mauja Dabgram under PS Bhaktinagar, ward number 41, SMC, such and such. Property situated at Sevok Road, opposite Central Park. In view of the above, I request you to kind self to please supply me the above information. Now, my lord will, I have issued another letter on 9th of December, which my lord will find at page number 107. This is another RTI that I had used. This was issued to the Deputy Commissioner, Revenue and Secretary, State Public Information Officer, with regard to the same land and the LUCC, my lord. Now, my lord will kindly see the reply at page 109, which was issued by SJDA, Shiliguri Jalpaiguri Development Authority. To Dulal Kumar Dhar, son of late Lokhinarayan Dhar, With reference to the under subject above, following are the available information. For question number 1, Ajit Kumar Agarwal, Terai Tea Company Limited, Terai Infrastructure Limited, and Abhijit Tea Company Limited, Agarwala House, Sevok Road, Siliguri, has submitted online application on 7th of July 2021, VDA file number such and such, which is latest for a land recorded in RS plot number 235, 237, 238. Kindly marks 237 and 238. These are part of the suit property. 237, 238, corresponding to LR plot number 2, 3, 5, 6, 7, 8, 9, 12, and 13. RS sheet number 8 corresponding to LR sheet number 34 and 35. RS Khotia number 558, 569 by 1 corresponding to such and such. For question number 2, the case has been approved by SJDA authority and land use compatibility certificate has been issued. Question number 3, notice has been issued. And then, my lord, the fourth one is not relevant. Now, kindly also sees the reply by Siliguri Municipal Corporation, which is at page 110. This is again in reply to an RTI issued by my client, my lord, defendant numbers 2D. In reference to your letter as mentioned above, the information sought by you under RTI, this is to inform you reported by the concerned department that the building plan submitted by Ajit Kumar Agarwala, Terai Tea Company Limited, Terai Infrastructure Limited, and Abhijit Tea Company Private Limited, which was submitted on 26th of June 2021, pending for approval. Yes, notice, sir. Now, of all these names, my lord, Ajit Kumar Agarwala, Terai Tea Company Limited, Terai Infrastructure, and Abhijit Tea Company, they're all part of the same group, my lord. But Terai Tea Company Limited is the company in which the receiver was a director since 2014.
But the plan was submitted
in 2021.
Prior to the amalgamation application.
Yes, my lord. There are, my lord, the technicalities. One has to submit to an amalgamation application, my lord. That would be made for LUCC, my lord. That would be made to the Siliguri Jalpaiguri Development Authority. And, my lord, for the purpose of sanction of the building plan, my lord, that has to be submitted before Siliguri Municipal Corporation. So I had written to both, my lord, and both replied. One was an application for LUCC, another was an application for sanction of building plan.
The building plan that was submitted before the municipal authority or municipal corporation, it was prior to the
June 2021.
Yes, it is prior to the application for amalgamation made by Mr. Agarwala. The application was made on 7th July 2021, and this is June
5th of October 2021, my lord, LUCC was applied for. No, sorry.
7th July.
7th July 2021, yes. Online application 7th July, and this was 26th of June. Now, my lord will see RS plot number 237 and 238 I had shown. Kindly sees the schedule of the property, which was part of the plaint. Part of the plaint. I'm sorry, my lord, that's not part of the plaint. That's annexure B, my lord.
Yes.
That is at page 30. All the piece and parcel of land measuring 2 bigger 66 decimals, such and such, RS Khotia number 561 being a portion of RS plot number 237, 238, and 238 by 832. This, if my lord compares with page number 100 and page number 109. My specific question was also, and because I had provided in the RTI application the schedule myself, and I had received a positive response from both SJTA as well as SMC. The RS plot number matches, my lord. Ward number such and such. So, my lord, this was part of it. Now, once that I have been able to show that, my lord, kindly come back to page number 14 of my application.
Yes.
Clause B, page 14. Moreover, the said Ajit Kumar Agarwala, Terai Tea Company Limited, Abhijit Tea Company Private Limited, and Terai Infrastructures Private Limited appears to have jointly submitted a building plan to the Siliguri Municipal Corporation, Siliguri on 26th of June 2021 for its sanction and approval, which is pending approval in the Office of the Commissioners, Siliguri Municipal Corporation. Your petitioners have come to know of such fact on the basis of my lord, I had placed that RTI letter as well as response. C. It is pertinent to submit that the said Ajit Kumar Agarwala, Terai Tea Company Limited, Avijit Tea Company Limited, and Terai Infrastructures Private Limited entered into a joint agreement to promote and develop such shopping mall on the property. And for that purpose, the directors of the above companies passed resolution and executed powers of attorney and submitted the same to Siliguri Municipal Corporation for plan approval. The same would appear from the land use and compatibility certificate issued on October 5, 2021 by the Siliguri Jalpaiguri Development Authority. For page number page number 2. This is the LUCC, my lord, which was granted by SJDA, is at page 111 of my lord's brief. This is a document dated 5th of October 2021. Is it legible, my lord?
Yes, yes.
Kindly sees to see such and such. I am not repeating the name. Subject taken out. Subject land use compatibility certificate under section 46 of the West Bengal Town and Country Planning and Development Act. In reference to his or application dated 9th of September 2021 on the subject quoted above, the proposed institution of use or change of use of land from industrial to mercantile commercial building development for land area of 11237.46 square meters, site plan enclosed at Siliguri Municipal Corporation. Kindly sees, my lord, LR plot number RS 235, 237, 238. LR 12, 13, all in sheet number such and such. Ward number 41, Moja Dafgram, jail number 02, Dafgram Urban under Bhaktinam. Now kindly comes, my lord, to the next paragraph beginning with the words with reference to the application.
What is the purpose of LUCC? Why it is required?
I don't have much technical knowledge about this, but what I understand is that you have to get a LUCC and you have to, if we are here to construct a building, my lord, we have to get a building plan sanctioned by the municipal corporation, KMC for instance. But there, my lord, there we have to obtain a building plan duly sanctioned by the municipal corporation. And my lord, also, my lord, the name is Land Use Compatibility Certificate. It is a requirement under the West Bengal Town and Country Planning Development Act. But my lord, these are the steps that were required for construction of any type of construction. In this case, a shopping mall.
And the requirement is most of these lands are tea gardens or estates or agricultural land. For the purpose of carrying out any construction, that approval is required because there are forest
It's a sort of
lands.
approval of compatibility of the land.
Yes, my lord. It is
And
just
thereafter the conversion has to be made.
requisite conversion.
Yeah.
My lord, if kindly please that paragraph just after the portion I read, which begins with reference to the application mentioned above, the Siliguri Jalpaiguri Development Authority does not have any objection for development of the scheduled land for mercantile purpose, subject to the following conditions as stated below. Permission for conversion must be obtained by the applicant from the competent authority under the West Bengal Land Reforms Act. Permission of development is without prejudice to any other law. Nothing else is required, madam.
Yes.
Now, my lord will kindly see the plan is at page 113. Yes. This is the plan which was submitted, my lord, and it includes the suit property as well. I'll indicate the exact particulars. I could have marked it in the before filing it, my lord. I'll show it later on, my lord. But may I come back to my application, my lord? Yes. Kindly comes to page number 15, subpara D. it would appear from the paper publication made by the receiver as stated herein above that this honorable court had directed construction of a boundary wall around the said property. However, the said wall has been demolished at the behest of Rajendra Kanodia. My lord, I had showed the newspaper publication where a boundary wall was required to be constructed and it was constructed. However, the said wall had been demolished. This is my averment, my lord. However, the said wall had been demolished at the behest of Rajendra Kanodia, Ajit Kumar Agarwala, Sitaram Sharma, Kamal Kishore Biani, and Arun Tharad, all directors of such and such companies, which is evidenced by Bhaktinagar Police Station case number such and such dated December 3, 2021, under such and such sections, a copy whereof is annexed to and marked. And I had lodged a complaint, my lord. Strangely, the present receiver has not attempted to bring such fact on record, that is the fact of demolition of the boundary wall, before this honorable court. Strangely, the present receiver has not attempted to bring such fact on record before this honorable court. Your petitioners have lodged complaints with Bhaktinagar Police Station, Jalpaiguri, the nature whereof would appear from the copies of the complaints. Para 26. The aforesaid facts have never been disclosed by the receiver or the plaintiff, and this honorable court was never apprised of the same. Such non-disclosure amounts to willful suppression of material facts and reeks of malafide. The receiver has failed to discharge the duty assigned to him and have failed to act as an officer of this honorable court. It is humbly submitted that the present receiver be discharged with direction to hand over possession of the said property to your petitioners. My lord, next page, para 28. It is humbly submitted that the plaintiff is a powerful and influential person. The plaintiff may attempt to mobilize men working under him to prevent the handing over of possession. As such, I have prayed for police protection. My lord, paragraph number 30. In the alternative, my lord, I have made out a case in the alternative. It is further submitted that the personnel of the receiver be changed and a fit and proper person be appointed a receiver in the place and stead of the present receiver. My lord, why I have my first prayer, my lord, is that remove the receiver and give me back possession. I am the owner. He has not yet become the owner. He is yet to begin his trial in the suit. Why should I be deprived of the possession of the property? If my lord thinks that no, the possession should not be given, then my lord, I would humbly submit that given what I have narrated and what I have demonstrated, my lord, the receiver, the present person, the personnel of the receiver should be changed and somebody, my lord, else should be appointed. Now, my lord, they have filed. My lord will see that in prayer portion, the first prayer that I had sought for is delay in filing the instant application be condoned. Because, my lord, I apprehend that an objection will be taken that an order which was passed in 1987, you are seeking to seek a contrary order today. But all that I am saying, my lord, this prayer I have made by way of abundant caution. Today, I have stated that an injunction which can be granted today can be vacated 2 days thereafter or even 20 years thereafter, provided the conditions of CPC are satisfied that it was obtained either by fraud or by misrepresentation or it has caused undue difficulties for the person against whom the order of injunction is being passed. I had tried to demonstrate that the property being outside jurisdiction, suit, if it was filed there, my lord, I wouldn't have this case to make out. But since I can, my lord, today, I am saying that the property being outside jurisdiction, otherwise, my lord, today suits will be filed in Calcutta High Court and people will be taking possession of properties in Delhi, Nagpur. Nothing is stopping them on the basis that the agreement was entered into within the jurisdiction. So, my lord, now that I had sought for also, my lord, prayer B, where I had sought to leave be granted to serve a copy of the application against the receiver. Obviously, because I'm asking for an order against the receiver, presently continuing receiver. That order was granted on the 14th of June 2022 and I had served upon the receiver. The receiver, my lord, had filed an affidavit in opposition. Kindly takes the affidavit in opposition of the receiver. It is an affidavit which was affirmed in August 2022.
August 2020.
Yes. My lord has found it. My lord, kindly see what is the stand of the receiver. Paragraph number 3. They stated that it is without any basis, factually incorrect and a device to malign me as a receiver. I have, to the best of my ability and regard to the fact that the Honorable High Court at Calcutta is the custodial legis of the suit property and have aspired to ensure that the suit property was free from any acts of trespassing or otherwise subject to any wrongful acts at the instance of third parties. for more than nearly 30 years. It is also to be put on record that till date, said property is in my possession and my control and presently is buttoned and bounded by a tin boundary wall. The newspaper publication said, I'll just indicate once again. Kindly give me one moment, my lord. Does not mention in the newspaper publication, it simply says, further upon report of the undersigned, his lordship was to direct further to construct boundary wall by the petitioner for the purpose of protection of the land in question. It does not mention what was the nature of the boundary wall, but here it says it's a tin boundary wall. 2 bighas of land, my lord, a tin boundary wall, which is locked by me, and the keys of the gate to the suit land is lying with me. Now, kindly sees paragraph 4A and 4B, my lord, it goes to the factual aspects which are admitted, my lord. Now, kindly come to paragraph number F. Paragraph number F at page 4.
You have the copy of the order dated 20th May 1987?
Yes, my lord. That is, I had showed, my lord, at which is at page number. My lord, that is the first annexure that I showed to my lord at page number 31 of the application, my lord.
Okay. The construction of the boundary wall was in terms of this order?
No, my lord. This was a subsequent order. Which order, my lord, I was unable to trace out. That, my lord, will find from the newspaper publication. I am relying on the newspaper publication only to find out, my lord. I believe that order would be dated 2nd of June 1987. Because the typed copy of the newspaper publication at page 97, second paragraph says, subsequently on 2nd of June 1987, the undersigned has been appointed as receiver instead of Mr. Ashok Kumar Mitro. Further, upon a report of the undersigned, His Lordship Justice A.K. Sengupta was pleased to direct further to construct boundary wall by petitioner for the safety and protection of the land in question. My lord, this is being a very old suit, my lord. Most of the orders, my lord, we are relying on the newspaper publication themselves, my lord. Now, if my lord kindly comes back to paragraph 4, subpara F of the affidavit relied upon by the, my lord, receiver. Here he has stated, Lokhinarayan Dhar being the original defendant, died sometime in or about 16th of November 2005. This is the defendant number 2, my lord. But thereafter, I was not informed about the substitution of his legal heirs in the instant suit till much later on. In view of the long period of time, nearly 35 years, the existing boundary wall had been dilapidated and broken at various places, for which I instructed the plaintiff to ensure construction of a boundary wall with an added height so as to afford full protection to the property, which was ultimately done by the plaintiff sometime in or about November 2021. Thereafter, I received a copy of this instant application. So, pausing here for a moment, my lord, the receiver gets in touch with the plaintiff and asks him to prepare the boundary wall. There is no intimation given to any of the defendants. I am not concerned about defendant number 1 to the legal heirs of the defendant number 2. No intimation given. A receiver is usually to act upon notice of all the parties. Here it is, I had instructed the plaintiff to ensure construction of a boundary wall with an added height. The plaintiff is nothing but a plaintiff in a suit for specific performance. I continue to be the owner, and the owner is not notified that the property's boundary wall has been dilapidated and it needs repair. Now, thereafter, I received a copy of the instant application H for my discharge filed by the defendant numbers 2A to 2H, wherefrom for the first time I was made aware of the fact that after the death of the original defendant, defendant numbers 2A to 2H has been substituted. In this context, I further submit that the substituted defendants had never informed me earlier about their impleadment in the aforesaid suit, and therefore I was not aware as to who were the defendants who were substituted after the death of the original defendants. So the receiver does not say that he did not know about the death of the original defendant. The receiver says that the substituted defendants, the legal heirs, did not reach out to the receiver. Not for one instance, the receiver sought to ask such clarification from the plaintiff, whom he had been regularly passing instruction, construct boundary wall, this, that. The plaintiff post-substitution amended the suit, amended the prayers also. Plaintiff knows everything, but not for one instance. The receiver wrote to the plaintiff saying that such and such defendant has died. Give me the particulars of the legal heirs who have been substituted. Not only that, in this particular paragraph number 4H, in this particular paragraph H, the blame is squarely being put on the substituted defendants. I would have understood that if he had said that the parties to the suit never informed me. But no, the substituted defendants never intimated. This raises my suspicion even further, that the blame is entirely being put on me, the widow and the children of the original owner. And the plaintiff is only there to construct boundary wall. Anyway, thereafter, my lord, now my lord will kindly see the dealings of my averments made in the application by the receiver. Kindly comes to paragraph 9 at page 6 of the affidavit. My lord, it's admitted. If my lord sees paragraph 9, 1, 2, 3, 4, 5, 6, 8th line from the top of paragraph 9. The mere fact that I have been appointed as an independent director in Terai Tea Company Limited, which is not a party in the instant proceedings, cannot lead to an automatic presumption that I, as a receiver over a property in which the plaintiff is a director in Terai Tea Company Limited, be said to have a conflict in interest for which I should be discharged over the said property. So, my lord, everything I had stated in my application, factual aspects, stands admitted. Yes, the plaintiff is a director of Terai. Yes, the receiver is also a director of Terai. Yes, I've been there since 2014, but that does not mean that I have any conflict. That is the statement that the receiver is trying to say. The applicants had never informed me that they were substituted after, again, my lord, the same allegation, same blame being put on the applicants. The applicants had never informed me that they were substituted after the death of the original defendants till the time the said application was served on me. In any event of the matter, there is no requirement in law or under any of the orders passed by this honorable court as referred to herein above that I was under an obligation to inform either this honorable court or parties in the proceeding regarding appointment of a director in another company which was not a party to the instant proceeding. So the only defense is Terai Tea Company Limited is not a party to the suit. I can become a director of that company. No problem. But the plaintiff is also a director and you are supposed to act as a neutral party, neutral person in respect of a dispute between the plaintiff and the defendant.
Yes.
My lord, this is more or less repeated throughout this affidavit. There is no conflict of interest. This was a belated application. I am a senior most advocate in the circuit bench of the Honorable High Court at Jalpaiguri, and goes on to speaks about his bona fide, my lord. Kindly also takes now paragraph number 10, my lord, at page 7 of the affidavit. From the third line, I was an independent director of the said Terai Tea Company Limited. As an independent director, I was not required to go into the affairs of the company and I did not venture into the same. So these are, my lord, explanations. The subsequent events as pleaded by the applicants had no concern with me, either as a receiver or as an independent director. Subsequent events, my lord, means pertaining to LUCC, because my lord will see while they are dealing with the allegations made in paragraph number 27. In paragraph number 27, my lord, I think there is some incorrect dealing. It should not be paragraph 27, it should be read as paragraph 24. Because my lord will see paragraph 9 of the affidavit of the receiver is still paragraph 22 and 23. So my lord, it's a typographical error which is more apparent because it says Allegations made in paragraph 20 and various sub-paragraphs thereunder. The sub
11. Para 11. Para 11 says 25, 26,
Yes,
27.
this is typographical error. Kindly reads that at paragraph 24. This paragraph 24 of my application deals with LUCC, building sanction plan, police complaint, destruction of boundary wall, all of them. Kindly sees, I was an independent director of the said Tera IT Company Limited. As an independent director, I was not required to go into the affairs of the company and I did not venture into the same. The subsequent events as pleaded by the applicants had no concern with me either as a receiver or as an independent director. So, my lord, the facts are there. He is simply saying I was not involved. Does not say that the sub-paragraphs in which because I have obviously supported with supporting documents, my lord. He says thereafter, I call upon the applicants to produce any document on the basis whereof they can prove any complicity on my part with regard to the applications made for development of the said land, either before SJTA or the application for grant of building plan before the Siliguri Municipal Corporation. I had never signed any papers, documents or any power of attorney empowering Tera IT Company Limited and others to obtain land use plan from the Siliguri Jalpaiguri Development Authority or a building plan to be filed before the Siliguri Municipal Corporation. I state that the applicants had never informed me that there was some dispute in the land over which I am the receiver and Ajit Kumar Agarwal and others had allegedly demolished the boundary wall thereat, which was the subject matter of Bhaktinagar Police Station case number such and such. It is not known as to why I was kept in the dark by the applicants with regard to the events mentioned in the instant application, even though allegations have been made against me on false and frivolous grounds of my alleged conflict in interest, on the basis whereof my discharge as a receiver of the suit land has been prayed for by the applicants. The applicants have also not informed me about the lodging of FIR before Bhaktinagar Police Station. Applicants, knowing fully well that I was receiver of the said property, have sought to bypass me for reasons best known to them and in this manner make a fresh case without giving me any semblance of opportunity to delve into the matter and find out the truth or correctness or otherwise of the allegations made by the applicants against the other persons, which thus casts a serious doubt as to their intention or propriety. So he's merely saying that I never authorized any company. All these acts were done, but they were not done by me. I was in the dark. The applicant should have come to me before approaching this honorable court. But not for once they say, the receiver said that these things did not happen. Now today, my lord, who is the applicant? Out of the various names that I read out, one is Tera IT Company Limited. It is an artificial entity. It's a juristic entity. It cannot act on its own. It's not a natural person. It has to act through the instrumentality of its board of directors. And who are the members of the board of directors? The plaintiff, one of them, the receiver, another. Today, he cannot feign ignorance saying, I'm an independent director and I'm not aware of the affairs of the company. That is an eyewash.
Yes.
My lord, these were the annexures, my lord. I have also part of the annexure there, my lord. Now, kindly seize. Now, kindly seize, my lord, the affidavit in opposition used by the plaintiff. It was affirmed on 11th of September 2023. Now, I had, my lord, from the very beginning, I've been saying that the plaintiff and the receiver has been acting hands in glove with each other. The receiver has squarely put the blame on me. It is the applicant's fault. They did not come to me. They did not inform me. They did not inform me about the substitution also. Plaintiffs, there was no accusation whatsoever. Now, kindly seize the stand of the plaintiff. The plaintiff's affidavit kindly takes, my lord, paragraph number 12 at page number 9. This is also an admission, but it is, I would say, more of a suppression than actual disclosure of truthful facts. Kindly see paragraph 12 at page 9. Has my lord found it?
Yes.
With reference to the contents of paragraphs 22 and 23 of the said application, save what are matters of record, allegations to the contrary are denied. It is stated that when Milan Kumar Sarkar was appointed as the receiver in respect of the suit property, he was not in any manner connected with Terai Tea Company Limited, which is, I also accept it. Subsequently, for a certain period, absolutely vague, in an affidavit before the High Court at Calcutta, is saying for a certain period without, and when there are severe allegations against the receiver, against the plaintiff, here also vague pleadings have been made. Subsequently, for a certain period, he became a director of Terai Tea Company Limited, but has resigned from the directorship long back. So, my lord, mark certain period, vague, and long back, that is also vague. No date is given. In any event, the plaintiff is not Terai Tea Company Limited and is by an individual, and the case made out in the paragraphs under reply is thus utterly irrelevant. It deserves mention that the learned receiver had merely erected a boundary wall around the periphery of the said property after being appointed as the receiver, and the property has remained as it is since then without the possession being handed over to anybody. Casting aspersions on the learned receiver is thus uncalled for and unwarranted. Now, my lord, certain period he said, the director, now kindly, I had already shown my lord the master data document which showed that the receiver was a director from 26th of July 2014, which is at page 100 of the petition. Now, I have also found out the letter of resignation that, my lord, I have annexed in my affidavit in reply to the plaintiff's affidavit in opposition. Kindly keeps this paragraph number 12 and kindly takes my affidavit. It was affirmed on 20th of September 2023. Day 22. কোথায় এটা? এখানে তো দেখতে পাচ্ছি না। কোথায় আছে? তো এখানে তো I'm sorry, my lord. I'll just. It is in the affidavit on reply against the receiver, my lord, affirmed on 13th of October 2023. Oh. 22. The document at page 106 of the petition, my lord. Yes. Yes, my lord. 100 and yes, my lord. Just a minute. It's 102. 102, my lord. Yes. Yes, my lord. That says 26th of July 2014. The beginning date. No, the document of the company. Yes, my lord. Master data document. Yes. This has been downloaded on 4th May 2022. Yes, ma'am. 2022 it was down. So it is correct that on the date of his appointment, he was not connected with Terai. It is a correct statement. 1987 he was appointed. He was not connected with Terai. His connection with Terai. Your case is that the steps being taken for LUCC and amalgamation, at that point of time, he was a director. He was a director and receiver both. Yes. He's still a receiver, of course. So my lord will see at page 100, the date of appointment against the name of Milan Krishna Sarkar shows as 26th of July 2014. The plaintiff states that he was a director for certain period and resigned long time back. Now kindly sees my affidavit in reply to the receiver's opposition. It's a 74-page document. Kindly comes to the last page, page 74. My lord, it's a letter of 13th of January 2023. Yes. My lord, will see now. Milan Krishna Sarkar, he writes to the board of directors of Terai Tea Company Limited. I am an active as a non-executive independent director of your company since 27th of September. This is also wrong. The document shows 26th of July 2014. However, due to certain preoccupation, I am unable to devote effective time towards the affairs of the company, including attending board meetings and other subcommittee meetings. In accordance with such and such, Hence, I request you to kindly release me from my duty, and as such, I tender my resignation from the post of director of the company. You are requested to kindly accept my resignation under intimation to me. Kindly find all the requisite forms with MCA and also inform stock exchange regarding my resignation. I wish a brilliant future for the company. It's a document dated 13th of January 2023. Terai Tea Company Limited has this document, and so does the plaintiff Rajendra Kanodia, being a director. Despite having this document, they suppressed it. And in their paragraph 12, they said that the receiver had resigned long time back. If I look at the date on which this affidavit was affirmed by the plaintiff, it was 11th day of September 2023. So from January to September, it became long time back. But they did not disclose this document. When was the application filed, GA5? My lord will see from the application, it was filed in April 2022. After I obtained an order from this court and served the application upon the receiver, that is when good senses prevailed and he tendered his resignation. So it was post-filing of this application for removal of the receiver that this resignation was tendered. So, my lord, the language that is used in paragraph 12 of the affidavit in opposition by the plaintiff, my lord, also suppresses more rather than discloses more. Completely full of vague allegations, certain period long back. And another thing, my lord, my learned junior points out,
Yes.
in paragraph number 12 only,
Just paragraph 12 of the
affidavit in opposition by the plaintiff, my lord, that certain period and long back, that particular paragraph 12 at page 9.
Yes.
My lord, it deserves mention that the learned receiver had, my lord, this is 7th line from the bottom, my lord, paragraph number 12 at page 9. The sentence beginning with, it deserves mention that. It is an affidavit in opposition.
It deserves mention, yes.
Yes, it deserves mention that the learned receiver had merely erected a boundary wall around the periphery of the said property after being appointed as the receiver, and the property has remained as it is since then without possession being handed over to anybody. Now, receiver's contention was that initially it was a tin wall, a tin boundary wall. Thereafter, it became dilapidated, and so he asked the plaintiff to erect the boundary wall. Here, the plaintiff says that the receiver erected the boundary wall. So there are contradictory statements galore. Now, my lord, other than this, now, my lord, may I only, now that I have more or less, yes, my lord, another fact which I have already placed the factual aspects of is that throughout this honorable court, as well as the defendants, have been kept in the dark. Willful suppression of material facts. A receiver who's continuing in possession of a property, immovable property from 1987. I have not seen one single notice, one single minutes, one single report. So whatever has happened with the property, even this honorable court does not know, other than the documents that I have been able to procure and I have annexed to my application. I don't know either. All that I've been able to find out that there was a proposal for amalgamating everything and constructing a boundary wall, constructing a shopping mall. Another thing, my lord, today it is a suit of 1987. Defendant number 2 died. Legal heirs were substituted, my lord. And I had also filed my written statement, which, my lord, I have pleaded. Yes. My lord, I had also filed a written statement, I meaning the legal heirs of the defendant number 2 had filed a written statement, which I mentioned in paragraph number 19 at page 10 of my application. I have also annexed the written statement, and it was filed on 2nd of July 2008. So the pleadings were completed in the year 2008, but from 2008 to 2024, almost 16 years have, more than 16 years have gone by. The suit has not proceeded to trial. Of course, I am also to blame because I should have prodded, pushed the suit to come to see the light of the day, but the plaintiff did not take any steps. They were happy with the receiver continuing in possession in their ultimate attempt to grab the suit property without obtaining any decree. Now, again, I'm sure I would be asked as to why this application is at such a belated stage, my lord. My lord, delay should not come in the way of substantial justice. Today, I am the owner of the property. In the books, records everywhere, the title still is with me. I am not in possession of the property. For 34 long years, the actual owner passed away. From 87 till 2006. 2006, he passed away. He couldn't see the property. The widow, the wife, and the children, they have also not been able to enter the property. My lord, delay should not come in the way of substantial justice. My lord, although I have prayed for my lord for condonation of delay, but I must point out that this is not an application for recall. I am not saying that order should be recalled. I am saying, given the facts and circumstances of the case, the receiver should be discharged. If he wants to get possession, let him get possession in accordance with law. Unless today he can demonstrate that I am in cahoots with other persons who will take over or transfer, because I am still under the order of injunction restraining me from alienating, parting with possession or anything with respect to the suit property. Let that continue. But why should another person sit over my property when I am still the owner, when I am still responsible for that property as an owner? My lord, there is a decision, my lord, of 1987, volume 2 Supreme Court cases, page 107. This is, my lord, 1987, volume 2 Supreme Court cases, page 107. My lord, this is, I'm hand over the judgment, but before that, I'm just reading a portion of it. This is in respect of Section 5 of the Limitation Act. My lord, where it says that substantive justice should be given way to, and one should not proceed on the technicality of the delay. My lord, here, my lord, a liberal approach is to be adopted on the principle as it is realized that ordinarily a litigant does not stand to benefit by lodging an appeal late. Refusing to condone delay can result in meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest that can happen is that a cause would be decided on merit after hearing the parties. Every day's delay must be explained does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred, for the other side cannot claim to have a vested right in injustice being done because of a non-deliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped that the judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. May I hand over the judgment, my lord? That's it. My lord, in a nutshell, the grounds are, my lord, I should be given back possession because the suit is simply stated for specific performance, not for possession. The receiver should any event be removed because of the allegations. Number 1, willful suppression. Number 2, boundary wall demolition, no information to anybody. LUCC, my lord, building sanction plan. And lastly, my lord, receiver and plaintiff should not be part of any organization, let alone be directors of a company. My lord, these are the humble submissions on the basis of which
And I'm appearing for the plaintiff in this matter. And my lord, before I start my submissions, I wish to indicate that in no manner this particular application is maintainable. Perhaps another disclaimer that I should bring before my lord is the fact that I do not come in the way of the personnel of the receiver. If the receiver is the court finds that the receiver should, particular person should not be the receiver, the court may change. The court has at the first instance appointed one person, later on appointed a second person. If the court appoints a third person, with regard to the personal, I do not come in the way. Today, I am only on the issue of the property and whether this particular order should subsist as on date. My lord, a lot of submissions have been made with regard to the change of the receiver, but my lord, my learned friend's first prayer is the prayer for condonation of delay. So if I may ask myself this question, that whether any of these prayers can be allowed before considering the prayer for condonation of delay, then my lord, I believe my learned friend has a lot of hurdles to cross, because my learned friend indicates that be that as it may, from 1987 till 2006, the original defendant number 2 was present. What steps has he taken? Even otherwise, my lord, the an application for recall of the recall of the particular order of appointment of receiver or discharge of the receiver was taken out as far back as 2009. My lord, in 2009 they filed an application which was dismissed for default in 2017. In 2017, after the dismissal, they file an application for restoration of that application with a delay of 1760 days, and that application got dismissed. And then they try to file, now they're trying to file another application by raising further and new cause with regard to the LUCC and the other sanction plans which we have applied for in respect of other, not we, rather the Teraiti company has applied for in respect of other properties. The plaintiff is only a director. The plaintiff is a separate individual. The particular Teraiti company and the other organizations are separate individuals. Whether this particular land falls within the purview of those LUCC and the sanction building plan is also something that has to be ascertained. Only because other properties, other plots of land which is owned by that third party, the other companies, fall within the same RS DAG number, it cannot be identified that this land is a part of that LUCC or the sanction building plan. In any event, my lord, may I first indicate to my lord from my affidavit, which I had filed in September 2023. My lord will kindly take up Mr. Kanodia's affidavit of 9th September 2023, and my lord will take page 16. $16.
60.
16, my lord. It's a short affidavit, my lord. It's only 18 pages, 17 pages. I am at page 16. Only one annexure, my lord, is the order of 27 November 2017. My lord will find CS 451, GA number 1928 of 2009. Dismissed. The order is dated 27 November 2017. None appears on behalf of the petitioner, nor any accommodation is prayed for. It appears that the petitioner is not interested to proceed with the matter. The respondent is present, and under such circumstances, application stands dismissed.
Yes.
So, my lord, this application, what is this application, if I may indicate? My lord will get the understanding of this application from the annexure that I have placed before my lord today by filing the rejoinder, affidavit in rejoinder. It is the affirmed by Mr. Kanodia on 9th of February 2024.
Yes.
My lord will kindly come to page 7. It's the order, start of the order of 29 January 2024. My lord will also see that IHGA number 5, 6, 8 and so forth is indicated. Now, my lord will kindly consider that GA number 6 of 2022 is filed praying for condonation of delay as well as for recalling of the order dated 27 September 2017 in GA number 4 of 2009, whereby IAGA number 4 of 2009 was dismissed. So, my lord, although it was indicated as GA 1928, my lord, perhaps after the CIS and the new filing system, this will be IAGA number 4 of 2009. Admittedly, there is delay of 1,760 days. Explanation is put forth in the application itself. Mr. Mukherjee vehemently argued that this application, which was dismissed for default, namely GA number 4 of 2009, was supposed to appear along with the suit in terms of the order of the single bench dated 10th of March 2011. Instead, the application appeared in the list not along with the suit and was dismissed for default. Accordingly, Mr. Mukherjee, this matter should appear along with the suit, and the impugned order of dismissal is not proper. The court is not sitting on appeal against the order passed by the coordinate bench on 27 September 2017. There is a long delay of 1,760 days. Explanation is not satisfactory and delay is not condoned. GA number 6 of 2022 stands dismissed accordingly. GA number 8 of 2023, directions are passed for affidavit. Now, my lord will kindly see the next page. It is GA number direction in respect of GA number 5 with regard to the listing of the matter and completion of the affidavits in the particular matter. Now, this is the entire order. So, my lord, a previous application for recalling was already filed. But there is no appeal which has been filed from this particular order, no appeal from the order of initial setting aside of the order. Now, my lord, another application of the same nature has been filed today and is being considered by creating certain new circumstances, which I will come to and deal with one after the other. So, my lord, the another issue I want to point out today is the huge hue and cry about no steps being taken in the suit. Plaintiff has done nothing. Nothing has happened ever since 1987. All this shall fall because from 2006, when the defendant number 2 has passed away, prior to that, up till 1987, no step was taken by the defendant number 2. They cannot come forward and show any step that they have taken with regard to removal of the receiver or any unjust act for which the receiver ought to be removed. My lord, the first application was in 2009 and they don't move it till 2017. Order of 2011 was the last order. Till 17, what have the defendants done for the purpose? My lord, this is an equitable ground, equitable release. What has the defendants done? I do not wish to blame anyone because of the matter not being taken up. Steps have been taken. I will show what steps I have taken as well in the meantime. But the matter could not be called. The matter was in the list from time to time. Several applications have been filed, and in due course, perhaps steps will also be taken in the matter for the purpose of its proper hearing and conclusion. But in the meantime, the defendant today alleging that nothing has happened in the matter should first come forward and show what steps have they taken in respect of their application, which has been clogging the board, for which the interlocutory application, while not decided, the suit could not start as a matter of fact. So, my lord, the defendants have also not taken any steps and their conduct is evident. My lord, another point has been, before I go to that point, I will also like to indicate one more issue. My lord, today, my learned friend has started with the submission that this court would not have jurisdiction. If this court has jurisdiction, order of possession cannot be passed. My lord, this court has assumed jurisdiction not on the basis of any wrong statement made by me. I have indicated the steps in the plaint which has happened within. I have sought for leave under clause 12. I have been granted leave under clause 12. I have filed applications and obtained necessary orders by direction of court. My learned friend has not come forward here before this particular suit, file any application for Order 7, Rule 11 for rejection of the plaint on account of territorial jurisdiction, nor file any application for revocation of leave granted to me under clause 12. And that defendant was alive from 1987 till 2006.
And I'm sorry to interject. Perhaps my argument, perhaps I was unable to explain my argument. I did not challenge the maintainability of the suit. I am saying, since no relief of possession has been asked for, a receiver should not be appointed or directed to continue. That is it, my lord.
My lord, I will now come to the point why a receiver, the court felt that a receiver was required to be appointed. My lord will kindly take my learned friend's application.
Other matters is discover it continue good.
My lord may now kindly take up my learned friend's application itself. My lord will see that my lord had made an inquiry with regard to whether there was any order for construction of a boundary wall. And it was indicated that there is no such order, nothing could be traced. But may I place an order? My lord, the particular date indicated therein was incorrect. My lord will kindly take page 35, if I am correct with my calculation, my lord, -1. So it will be page 35 of the brief, my lord. An order passed by Ajit Kumar Sengupta.
Yes.
My lord will kindly come to page 35, suit number 451 of 1987, order dated 2nd May 1988. My lord, it was not June, it was May. Perhaps it was a typographical error. My lord will now see the petitioners. There are the petitioners and the plaintiffs who are appearing before the court on that particular date, my lord. The petitioners are added as party respondents. The order dated 26th of April 1988 is modified and or varied as follows. It is recorded that the petitioners have purchased 31 decibels of land as more fully described in Annexure I of the petition. Out of the 66 decibels of land being the subject matter of the suit, and the petitioners are presently the sole and absolute owners of the said 31 decibels of land more fully described in Annexure I to the petition, hereinafter referred to as a said plot. It is the petition, it is stated on behalf of the plaintiff that he has agreed to purchase from the petitioners, and the petitioners have agreed to sell to the plaintiffs the said land as herein stated at an aggregate price of 39,000, and that the plaintiff and the petitioners have further agreed that the sale of the said plot of land shall be made in favor of the plaintiff and or his nominee in accordance with the two draft deeds of conveyance, both being Annexure K to the petition. It is stated on behalf of the petitioners that the statement made on behalf of the plaintiff and recorded herein is true and correct. Accordingly, it is ordered that the petitioners do sell the plaintiffs and or nominee or nominees of this nominees the said plot of land more fully described in Annexure I to the petition at the aggregate price of rupees 39,000 in accordance with the two draft deeds of conveyance being Annexure K. In view of the matter, the receiver already appointed over the said plot is discharged and will make over possession of the said plot of land to the plaintiff and or his nominees in whose favor the conveyance in respect of the said plot will be executed. The said receiver will, however, carry out the earlier order of 20th May to 1987 passed for construction of boundary wall in respect of balance 35 decibels of land after excluding the plot of land being 31 decibels, the suit will continue only in respect of the aforesaid balance 35 decibels of land. The order of injunction passed on 26th of April 1988 against the petitioners, restraining them from selling the said plot of land, is vacated, and they are directed to sell and dispose of the said in terms of this order. The petitioner given undertaking to this court to carry out this order, and such undertaking is recorded and accepted by this court. The application is accordingly disposed of. The receiver and all parties, including the petitioners, to act on a signed copy of the minutes of this order on the usual undertaking. So, my lord, this is the usual order which was passed. My lord, there, after I had filed the suit, there was a party who was encroaching on the particular land, claiming to be the absolute owners out of the 66. My lord, here is the important question about what is the suit property, what is the 31 decibels, and what is the 35 decibels. Today, the suit is not in respect of the entire 66 decibels. By this order, and this order has not been challenged. By this order, today there is only a limited 35 decibels of land remaining on the suit premises. Before, as a petitioner, if I am asking for any order of injunction or I am trying to vacate an order of injunction, I should come with clean hands. I have disclosed this particular document. I have not made the document a part of my submissions. I should have come out with clean hands, but this has been suppressed. That is the nature, because today he is still claiming in respect of the 66 decibels and filing RTI applications, representing himself to be the owner of 66 decibel in other forums and trying to obtain documents to show that some violation has happened in respect of the 66 decibels. But that is not the subject matter of the suit anymore. The subject matter of the suit is only limited to 35 decibels. He had already sold away that portion, which is why the court in 1987, by the order of 20th May, my lord, was impressed to appoint a receiver over the particular plot. My lord,
In this GA application, in this order, who is the petitioner?
the petitioner was a third party, my lord. I will show from his own averments in paragraph 16, my lord, of the petition. 16, no, my lord, not 16. Yes, my lord, 16 of the petition. My lord, will kindly come to 14. Sorry, my lord, 14. Page 8 of the petition. It also paragraph 14, page 8, paragraph 14, my lord. It is at the bottom. It also transfers that pursuant to an application made in the instance suit by one Narayan Mahato, Subhash Rai, and Anand Bandhu Roy, the Honorable Court was pleased to pass an order dated 26th April 1988 restraining Narayan Mahato and others from selling 31 decibels of land from the said property. Subsequently, the order dated 26th April 1988 was modified by way of a subsequent order of 2nd May 1988, by which the Honorable Court was pleased to direct that said Narayan Mahato and others to sell and dispose of 31 decibels of land to the plaintiff in terms of the said order. The copy of the said order dated 2nd May 1988 is annexed to and marked as annexure as E. And my lord, this paragraph is true to his knowledge.
So who is Narayan Mahato?
My lord, in respect of the 61 decibels of land. There was an agreement for sale with the defendant number 1, and the defendant number 1 has appointed me as the nominee. In the meantime, the plaintiff, being apprehensive that certain third parties were taking over the 66 decibels of land, had instituted the suit. Upon institution of the suit, we get to know that the particular land was already sold to 3 individuals, these Mahato and the 2 Roys. So after the suit is filed, injunction order is passed, receiver is appointed, they come up before this court, and the plaintiff enters into a settlement with these 3 particular persons who had purchased claims to have purchased the land, and I pay the amount of 39,000 which they claim to, on the basis of which they were the owners of the land. I pay that amount and I take that 31 decibels of land, title in respect of that, and only 35 out of the 66 decibels of land remains the subject matter of the suit, for which I had initially claimed the specific performance in terms of the agreement entered with the defendant number 1. And my lord, this particular document
Yes.
has been affirmed as true to their knowledge. So, and my lord, my learned friend has said that I am the owner and I am being deprived for 35 years, which is why I have come after 35 years and you give me justice. My lord, if I was the owner, like the Mahatos, I would have come within knowledge of the particular order within less than a year and have resolved the issues. It is
Yes.
what has been submitted cuts both ways, my lord. An owner who is aggrieved would have come up immediately. A person who may not have any right in the land has only come up after 35 years. Firstly, 20 years under the original defendant, and even after the original defendant passed away in 2006, my lord will see their conduct till 2022, where their applications have been dismissed for default, restorations have been filed after 1700 days. 1760 days. So my lord will see their conduct in coming and complaining that no steps have been taken in the suit. If they were to ask for a vacating or a recall of the particular order, there is nothing on their conduct to show that any equitable relief can be granted to them. My lord, so I have firstly, with regard to prayer 1, the hurdle of delay, condonation of delay, even if a pedantic approach is taken, even if a liberal approach is taken, even if someone says, I do not wish for explanation of ground day by day, my lord will kindly see their conduct in waiting for 35 years to come up for filing an application when they had knowledge. My lord, their guards had knowledge in 1987. They had knowledge of this order of 1988. And subsequently, my lord, I will also show how they have been brought in as well. Now, my lord, with regard to my steps, my lord, as I had indicated, or I was trying to indicate to my lord would kindly take up the plaint once. I just want to show from page, from page, my lord will kindly first come to page 26. My lord, the plaint starts at 22. My lord will kindly come to page 26 once.
Yes.
My lord will see that at paragraph 12A and 12B, I have taken steps for the purpose of adding the defendants. Yes. And my lord, it has been re-verified by the plaintiff at page 29. In January 2006, I had already applied for the re-verification. So, my lord, it is not that I am a plaintiff who's trying to not trying to move with the matter. I am sleeping over the matter. But certain directions were passed. There were no directions for filing minutes, annual reports, or anything by the order of 2nd June 2nd May 1988. The receiver may not have taken steps. The plaintiff has. Today, the plaintiff, if the order, I have given this disclaimer at the beginning. I am not trying to defend the personnel of the receiver, but I am trying to defend the receiver, the appointment of the receiver, and the fact that there should be a receiver over this particular property. That is my submission. My lord, they have not suffered any prejudice, which is why they did not come up for 35 years. My lord, there was no direction for any report, minutes, any form of documents to be filed in the meantime, for which the receiver, having not filed or no record being there, can be called upon. My lord, if there were certain directions and it was not complied with, it would be a different issue. And my lord, the plaintiff with whom the carriage of proceedings is there, the plaintiff is the person who had spent for the purpose of having the receiver appointed, boundary wall being constructed at the first instance. It is the plaintiff with whom the carriage of proceedings is there, and on the direction of the receiver, if he creates a boundary wall, if it was in a dilapidated condition, if he even constructs a boundary wall, that is not in any form of breach of the order.
Yes.
And it does not cause them any prejudice. My lord, now I want to indicate that my learned friend has referred to his aghast that he was not aware of the fact that it was only a tin boundary wall. And he was trying to complain that the receiver has not complied.
Yes.
My lord will now kindly come to page 119. My lord, I should indicate that it all starts from 114, which is annexure N, but I wish to refer to the complaint, the typed copy of the complaint, which starts at 119. Oh no, my lord, it is a different complaint, or may kindly come to page 119.
Yes.
My lord may also take up page 117 first, because it's the first complaint that has come through, 23rd November 2021. My lord, this is an allegation that with the help of muscle men, on page 117, my lord. Complaint by Dulal Kumar Dhar.
Yes.
My lord, this is a complaint which is with regard to muscle men coming into the property and causing problems. I am not really on this, but this was the first complaint. I should indicate the first complaint. Now, my lord will kindly come to the second complaint, which is at page 119. My lord will kindly come to the middle of the page, the right after. My lord, I will come. It's a very longish sentence, but after my lord sees that in Calcutta CS suit number so and so, suit is still pending, and the other suits also pending before the High Court and the District Sessions Court at Jalpaiguri, and the boundary wall around the suit property was constructed under the order passed by the Honorable High Court Calcutta, and also the receiver was appointed by the honorable court over the suit property, and one signboard was also fixed and placed upon the suit plot by the learned receiver, and especially the boundary wall on the southern side adjacent to Terai Tea Factory pre-existed, belonged to us, and was willfully, illegally and wrongfully demolished in utter violation of order passed and recorded by the Honorable High Court. The above named persons named in FIR so and so dated 2nd December 2021, knowing, willfully, deliberately and purposefully change the nature and character of the suit land under dispute, and still they are continuing in the process and in the manner. So, my lord, they themselves admit that there was a boundary wall.
Yes.
So, tin boundary wall, brick boundary wall, even the boundary wall which has now been, which was in a dilapidated condition, which has been raised by the plaintiff, that cannot be complained of. All these complaints, when this in 2021, the boundary wall was, steps were taken for the purpose of reconstruction of the particular boundary wall. It is only then that they have filed these 3 complaints and tried to fish out other documents from the municipality and the getting to know about other permissions in relation to the premises around, in and around that area, which also belongs to one of the companies where the plaintiff is a director. They are trying to merge both of them together. My lord, I again indicate that I am not defending the personnel of the receiver at all, but the appointment of a receiver and the receiver being in possession of this land is necessary, looking at the conduct of the plaintiff.
Asun.
May I continue?
Ask him to come on the next date, fixing a date for further hearing. He
I
complete the
should not take more than 15 to 20 minutes maximum.
Or Mr. Devdut Mukherjee, learned advocate for the petitioner, who concludes his argument. Mr. Ratul Das, learned advocate for plaintiff, also places his points of argument. Learned advocate places that due to paucity of time, the hearing could not be concluded. Learned advocate for the receiver seeks accommodation to make his submissions on the next date, on the returnable date. Is this matter one? Sir, if he is unable to come, Mr. If he is unable to come, you be posted with what are the facts and the contentions of the receiver. Because since I have started, after his completion, he will make, then he will get his opportunity. Yes.
Plaintiff respondent. Application respondent.
Pardon? February 1st में देखो तो Felix পরে একটা ডেট দিন ওরা মানে ফেব্রুয়ারি মাসে করি ফেব্রুয়ারিতে করো 11th February
11th February, my lord. I'll be there.
Any date, my lord.
ওটা রাখবেন মানে যদি অ্যাপ্লিকেশনটা শুনতে পারি
My lord, may I also request GA8 to be brought, rather listed on
What
that
is
date.
GA8?
GA8 is an application by a third party who is now claiming to be the owner of that 35 decibels of land. I wish for that particular application to be dismissed as well. Would it be
This application and that application
not
are not
connected to him, but
Let
then
us
I'm
first
the
complete
plaintiff.
this one.
some other day? Why
Very well, my
You
lord.
are not
After
the
my lord
applicant of that. You are not the applicant of that.
No, I am opposing, my lord.
Yes.
I'm opposing.
Let the applicant. এই যে। এটাকে একটা ফাইলের মধ্যে দিয়ে রাখো
Otherwise, on the
এটা থেকে গেল কি বলছিল হুম না না কালকে দেখবো টুমরো উইল সি না দেখে লিস্ট না দেখে নেবো না টুমরো উইল সি গ্রেটফুল টু